Please, Lordship. Lordship, I beg to mention item number 55 and 56, Lordship. Matter will be adjourned for a week, Lordship. Lordship, respondent number 4 have filed an affidavit. We'll file a reply to that. So 1 week time may be granted to us, Lordship.
Filing affidavit.
Yes, we will file a reply.
Don't mention now.
May I please, your lordship? My lord, I beg to mention item number 44, my lord. Here we have to file our affidavit in opposition, my lord. We have filed an adjournment request yesterday also. Actually, this matter may come after vacation.
44.
My lord.
At the request of the learned counsel appearing on behalf of the petitioner,
Respondent FCI, my lord.
responding. FCI,
FCI.
matter stand adjourned. You have taken the consent
Yes, I filed an adjournment request yesterday.
to be listed after on 11th of November.
May I please, your lordship? Your lordship, would like to mention two petition for listing, your lordship, pending matters, your lordship, pertaining to the non-clearance of the contractual bill of the petitioners, your lordship.
Bell 4.
May I please, your lordship? Lordship, I beg to mention a case for withdrawal of the case, my lord.
Friday.
I beg to mention for listing the case. This 19 matters, my lord. We are responding. The revenue board's appeal. There is that the appeal requisition preferred, my lord. There is some urgency because already a compensation. So next week, my.
No, not possible. You want a disposal?
Yes, otherwise, in fact, was already final result given by the revenue board. I will place it.
Okay. Then we'll have it on 20.
Hello?
20.
May I please, lordship? I beg to mention item number 26, my lord, on behalf of Mr. A. Deka. Kindly adjourn the matter for a week, my lord. He is out of station. 26.
The request of the learned counsel for the petitioner matter stand adjourned to be listed after the puja holiday, after the in the month of November 2020.
May I please, your lordship? I beg to mention item number 15, my lord. The petitioner wants to withdraw this case, my lord.
Mr.
S. Sancheti, my lord.
S. Sancheti, the learned counsel appearing on behalf of the petitioner submits that the petitioner is no longer interested in proceeding with the instant proceedings. Accordingly, the instant company petition stands closed on withdrawal.
Hello.
May I please, your lordship? Lordship, I pray for listing a matter for admission, which is last posted on 1/5/24.
Why?
Subject matter: husband of the petitioner was killed by the accused person.
You skill.
As your content.
27.
Let's
Good morning, my lordship. My matter is a WPC case number 1481 2024. I'd like to mention the matter as urgent for seeking list on 16 September 2024. My lordship, kindly please allow me.
Okay, 27
27 September.
November. This September.
May I please, your lordship? Lordship, on the last occasion, your lordship was pleased to direct the executive engineer public works road department to appear through DC lordship and seek instruction from. He is respondent number 3, lordship.
Yes, what is your instruction?
Lordship, my instruction is that on December 2023, the executive engineer wrote to the settlement officer to demark the land for the repairing of the existing road. And accordingly, on February, he
they demarcated the land and the construction was going on. Only when it came nearer to the petitioners, there are about 7 petitioners. Lordship, they objected that portion of the work has been stopped, and thereafter they have again started repairing the work. And as per Lordship direction, the executive engineer is on personal appearance to the ceiling.
Yes, Mr. Executive Engineer, is there any requirement of any acquisition of the petitioner's land?
Namaskar, sir. I am
Ah.
Anirudh Nath, sir. I am executive engineer, Silchar and Udarman Retail Road Division, sir.
Take a seat.
Sir, sir, we don't require any private land, sir. We have
Ah.
already government land, sir, about 90 to 95 feet, sir. Sir, already we have written to the settlement officer and assistant settlement officer. Accordingly, sir, they sent their field demarcation team and they demarcated the land and marked the boundary of our road, sir. And after the marking of the boundary, sir, we actually started the work. And while we got the objection from that party, we immediately stopped the work, sir, in front of their plot of land. And the disputed plot
But
of
you
land.
don't, but you are not, in any manner, you are not infringing upon the petitioner's land. No,
No, sir, it is our government land, sir.
it's a government land.
90 feet, sir. Sir, average government land is 90 feet to 96 feet, sir. There.
So the government land, you are constructing the footpath and the road, as well as the drain on the government land.
Yes, sir.
You do one thing, you file an affidavit in that regard, okay?
Okay, sir. Okay, sir.
That it is only in the government land you are going to construct.
Okay, sir.
Else, this court has no problem. If it is in the government land, yeah, you do it as soon as possible as you have stopped the construction.
Okay,
You
sir.
have stopped the construction in view of the pendency of the petition. Within 7 days, you file your affidavit stating
Okay, sir.
that you are only constructing on the government land.
Okay, sir.
Okay?
Okay, sir. Thank you.
This matter again on today is what?
Affidavit, sir.
11. We'll have it on 18th. Just that affidavit to that effect, that you are only going to construct only in the government land. Then the petitioner has no business out there.
Lordship,
No business.
till then we may be protected, Lordship.
What protection? No protection business. They are not constructing out there because of the pendency of the petition. That is why I'm asking them. That took violence. Because if they are constructing on the government land, you have no business. And also bring on record the demarcation which have been made. There's some demarcation proceedings must be. So bring on record it as to that you have requested that the settlement officer and the settlement officer, the office of the settlement officer had demarcated, and there is some order to that effect or anything to that effect to show, and then just mention that you are only going to construct in the government land, nothing more than that. With this, you file an affidavit. We are having it on 18th. Okay? বুঝি পাইছে না 18th লম তার আগতে affidavit খন ফাইল কৰি দিব This matter again on 18th 9/2024 on which date the executive engineer PWD Roads Kachar shall file an on or before which date the affidavit the executive engineer PWD Roads Kachar shall file its affidavit as regards to the effect that the land wherein they are going to construct the drain cum footpath is in the government land. The personal appearance of the executive engineer is dispensed with.
One promotion.
Oh.
My lord, after the last occasion, we have written to the department. File is being moved. We are seeking one more week, Lordship, to get instruction.
What is that order passed?
It's 11.
Have you made the verification?
For that, Lordship, the file has been moved by the executive to the chief engineer. One more week is required.
7 days.
7 days.
7 days. Verify. and bring it to the notice of this court. Once the verification is done, then the law will take its own course. Okay, very well. We are having it on 18th. Mr. Aibot Thakur appearing, the standing counsel of the PHE department has sought for some accommodation for the purpose of carrying out the accommodation on the ground that the verification is underway as directed by this court by the order dated 9/4/2024 in WPC number 2147/2022. Taking into account the above, list this matter on 28/29/2024. Okay. Just only to that effect that verification is due.
Number two. In this matter, my lord, I had written to the respondents, enclosing a copy of the order dated 2012-23 as well. And, my lord, I mean, I've not received any response from them yet.
The exercise is given. Okay. You have not received any response in
No,
spite of.
I've written to them.
And how did you serve upon the respondent number one?
register post করছি
Where is it? Where is it?
I have not managed to.
Then
Respondent number one lordship মানে lordship may kindly come to the page number 15. 15 lordship. By hand lordship. It was received duly received.
there is no page 15 in the petition. You have a page 15. I don't have a page 15.
Page 15 lordship.
No page 15. There's only page 14. You have a page 14.
I don't have, I'm yet to be handed over the copy.
I don't have a page 15. There's only till page 14.
Affidavit file করছে service of service দিয়ে করেছে affidavit file affidavit file করছেন না
There is no page 15.
service দিয়ে করেছে
It.
There is no page 15. No page 15. Here in the petition as per the index, there are page 14 only. Where are you getting the page 15?
14 lordship.
Page 14 is the seal of the deputy commissioner.
Lordship.
Where is the ear to the respondent number one?
Deputy Commissioner is respondent number one lordship.
What?
Sorry.
Then this service is not problem. The direction was given to whom?
The Deputy Commissioner lordship.
DC Carpian.
And it was received by DC Carpino Mulang itself.
Issue notice making it returnable on first of October 2024. No, let it be later on. On 23rd of October 2024. The petitioner is directed to take steps upon the respondent number 1 and 2 by way of registered as well as usual. The case of the petitioner herein is that this court, by an order dated 20/12/2023 in WPC number 7161/2023, had directed the respondent authorities to complete the exercise as regards the ascertainment and disbursement of the ex gratia payment to the petitioner within a period of 3 months from the date of receipt of the certified copy of the order by the respondent number 2. It is seen that the petitioner had duly served the said, had served the certified copy on 6/12/2023. However, the respondent authorities have not taken any steps in respect to compliance of the order dated 20/12/2023 passed in WPC number 7161/2023. This court also finds it relevant to take note of that when the matter was listed before this court on 2/9/2024, this court had requested the learned government advocate, Ms. S. Sharma, to take instruction as to whether the order dated 20/12/2023 passed in WPC number 7161/2023 have been complied with or not. However, the respondent, more particularly the respondent number 2, have not given any instructions to her. So under such circumstances, this court prima facie is of the opinion that there is a willful and deliberate violation. Accordingly, this court, therefore, the respondents are directed to file their affidavit before this court as to why contempt proceedings should not be issued against them. In the meantime, it shall not be a bar on the part of the respondents to comply with the order dated so and so past instance.
Lordship may pass over for the matter for the timing also.
What?
Meeting system is court number 5, Lordship in a division bench matter. Contempt petition Lordship. Again, the interim order Lordship at page 16.
There's another matter which I have directed, no.
Lordship, that is listed in court number 20 Lordship, in order column Lordship. Connected with petition Lordship. In which Lordship this interim direction was violated by you.
It has been submitted that the connected with petition being WPC number 2793. 2793 /2021. Is that the order? No. Connected with petition being 2793/2021 is listed before court number 20. Full stop. Accordingly, let this matter be listed along with WPC number 2793/2021 after on 23rd of September 2024.
Four.
Yes, what is this? Contempt?
Yes, Lordship, order dated 13/9/2023, passing WPC number 3389/2023. Lordship, operative part at page 11, paragraph number 3, Your Lordship. In this order, Your Lordship was directed the entire exercise shall be completed within a month.
Yes,
3 months, Your Lordship.
Ms. Hazarika, get your instructions on this matter.
Sole response.
This court have requested Ms. M. Hazarika, the learned standing counsel of the Revenue and Disaster Management Department, to obtain instructions from the respondent as to whether the order dated 13/9/2023 passed in WPC number 3389/2023 have been complied with. Full stop. The petitioner is directed to serve an extra copy of the petition to of a contempt petition to her during the course of the day. List this matter again on 30/9/2024, showing the name of Miss M. Hazarika as the in the cause.
I'm Sri Hazarika. Sri Hazarika.
E. Hazarika.
Lord.
Okay. Everywhere it's written as M. Hazarika. No.
I have corrected.
Okay.
So,
You get the instruction as to why it has not been complied with. And if it is, they don't come up like last time, last order, I will issue notice.
Milord, with regard to annexure 4, Milord, the direction has not been
That
complied.
is the order.
Your order page number 21. Your relevant portion, your lordship will find at page number 26.
Where?
26
Dispose
paragraph
of by
12 and 13.
directing the office of the district commissioner Nalbari to cause a demarcation exercised by the authorized and to demarcate the boundaries of the petitioner school as well as the Anganwadi center in Cochin. Okay, and then what did he do?
My lord,
Exercise of the power of so and so each month. Then 18(4). Then this is what? What is annexure 5?
annexure 5, my lord, in fact, a task force team was constituted, my lord, for the aforesaid purposes.
The following
But-
members as listed below, they who use the code.
Certain officials.
the demarcation. Then
But the demarcation was not done with. It was supposed to be done within a period of 60 days from the passing of the order, my lord. The order is of, my lord, 19/4/2024.
Mr. Esbolwa, get your instruction why it has not been done. This was a direction to the district commissioner. Just find out why. District commissioner,
Nalbari.
yeah, just find out why it has not been carried out. We'll take it up. Most probably, you see, there is the order out here does not say, there might have been some law and order situation and all. So this was to be directed. Therefore, this court, the instant contempt petition has been filed alleging willful and deliberate violation to the order dated 19/4/2024 passed in WPC number 6117/2023.
In fact, it was passed in the IA, my lord. One IA was filed, my lord.
Hey, both, no?
611.
System. It is seen that pursuant to the order dated
19/4/2024.
19/4/2024, task force was constituted by the additional district commissioner Nalbari. And the demarcation was to be carried out on 1/6/2024. However, it is the case of the petitioner that thereupon nothing further has been done. And as such, the petitioner has approached this court alleging willful and deliberate violation by the respondent. The order dated 19/4/2024 passed in WPC number 6117/2023. This court has requested Mr. S. Burwa, the learned junior government advocate, to obtain instruction as to why the order dated, as to whether the order dated 19/4/2024 passed in WPC number 6117/2023 have been duly complied with. And if not, what is the impediment, taking into account that the additional district commissioner have also constituted a task force. An extra copy or a copy of the contempt petition be served upon Mr. S. Burwa during the course of the day. List this matter again on 30/9/2024, showing the name of Mr. S. Burwa.
My lord, in the synopsis, my lord, actually, I have sent it the annexure 4, my lord. But here it has been inadvertently written as, my lord, annexure 5. So may I be allowed to correct,
Mr. Counsel, Annexure 5 is of in the month of May.
my lord? Yes.
We are concerned with there was a task force constituted on to make the demarcation on 1/6/2024. The other two documents which are there, you have enclosed, are all of the month of May.
My lord.
Don't come up much more. The more you come, I will dismiss your petition on that ground itself, on the two documents. There is no document subsequent to 1/6. You have? No. So better we keep quiet.
What I have intended to say, my lord, with the permission, my lord, that actually it was supposed to be annexure 4, but it has been written as annexure 5 only.
I'm not on that.
I have published.
I'm not concerned.
All right.
6.
Non-contempt?
Wait, please, your lordship.
Should the impugn that the order of passed in WBC number matter 2273 of 2014, page 8 matter.
Huh?
Page 8, annex of 1.
Which order you are alleging violation?
That is matter. Page 8 matter.
29 C, 26-9.
No, matter. Page 8.
Disobedience of which order?
Page 8 matter.
26-9 is at page 49.
Yes, there is a I have annexed with the representation. With the representation, I have annexed that order. I also annexed here also.
I'm
But-
only asking you, which is the order which you are asking? 26-9?
Yes, ma'am.
That is at page 49?
Page 49 as well.
Page 49, yes or no, Mr. Counsel?
In 2 times I have annexed this order.
Fantastic. Now asking you whether it is at page 49 or not.
Page 49.
Okay. Now tell me what is it?
Well, last
If
may
such
kindly see-
representation is
Please.
submitted by the petitioner within the time specified by this court, then the same be considered on merit and also after proper inquiry, the representation be disposed of.
page
Now, what is
51.
this?
Page 51.
What
the
is your
operative.
case for?
Well, it was for the compensation
Of?
of the son of the petitioner due to fall of my lord, the wall of a veterinary hospital, my lord.
Then you were supposed to submit a representation. Now, did you submit the representation?
Yes, my lord.
When?
May kindly see page 12.
When?
Well, it was submitted on 19/10/2023.
Where is it?
Well, in the page 12, left corner, my lord. You see by
Huh?
left corner. Page 12.
This one.
Yes, Lord.
So this is the representation you have submitted.
Yes.
Now this representation has not been disposed of. That is your case. When did you submit?
This was on 19/10/2023.
1910-2000 and thereafter. Okay. This is to be done by the Secretary Government of Animal Husbandry.
Yes, sir.
Issue notice making it returnable on 4th of November 2024. Petitioner is directed to take steps upon the respondent, sole respondent, by way of registered as well as usual. The case of the petitioner herein is that the instant contempt application has been filed alleging willful and deliberate violation to the order passed by this court dated 26/9/2023 in connection with WPC number 2273 of 2014. The ground alleged is that this court, by the order dated 26/9/2023, had granted the liberty to submit a representation before the respondent herein, and there was a further direction that the said representation be decided on merits within a further period of 6 months. The further case of the petitioner herein is that the petitioner submitted the representation on 19/10/2023 to the respondent. However, the respondent have not disposed of within the period of 6 months. The respondents shall file their affidavit bringing on record the standard. Oh. I've said now issue notice, I've get the date. 4/11 or something, no?
When?
A petitioner is seeking certain information from the Food and Civil Supplies Department regarding allotment and distribution of TDS item like atta, from which was distributed through two agencies, that is, my lord, Dhemaji RF Mill and Lokhisti RF Mill. Page 10 is the application.
And thereafter, my lord, one mill has supplied the information, but Hemaji RF mill has not supplied the information. And ultimately,
Now, what happened by the Assam State Information Commission? What did he say?
my lord, Assam State Information Commission, page 18,
Page
18. Clause 5 directed the SPIU to furnish the necessary information to the applicant.
the commission. Then why you are not approaching them?
My lord, this is the appellate highest body, my lord.
Huh?
Highest body of the state. my lord.
Understood.
And
Is there not a provision out there for taking initiative of contempt proceedings there? They have a self provision,
Yes, my lord.
section 20.
My lord, then page 22, page 22.
Then regarding compliance with the Iman to the proprietor of so and so,
Yes,
and
my lord.
information is so and so are available.
While
Yeah,
already
but
one mill
to
has supplied the
furnish
information, the other mill has not
The
supplied the
information
information.
for the applicant regarding distribution of wheat, sale register, so and so, so and so. Or this one are. So the information is not available with these officials.
According from 18 to 22, the required informations are not available with the departmental authorities, but all the information are available with the concerned mill. Last occasion you will lodge.
So how do you exercise that? How can the
Yes, ma'am.
Right to Information Act can be exercised
Last
against the
occasion-
third party?
Last occasion, your lordship asked me to put the queries, how long the department can procure the document. It is as per section A3, they have to procure the document for 20 years from the date of, prior to date of submission of the application, as per section A3. And public authority has the obligation to supply the document to the concerned applicant. My lord, the concerned.
Understood. If the authority does not have the document, how will they provide you?
My lord, the Yamaji RF mill has the document, my lord.
How do you say so?
Well, they have not denied, my lord, till
Are
today.
you challenging these documents where they say that they don't have it?
They have never informed us, my lord.
No, no, this is
Even my
this is apparent from page 22.
My lord, page 27,
Ah,
even my lord, last paragraph,
ah.
the documents from 18 to 22 are available with the department. Half the-
Where?
Last paragraph,
Page?
page 27. That information also not supplied to. Page 27. Last paragraph.
On
Yes,
receipt of the order by the commission, the undersigned had again instructed the proprietor to comply with the commission's order and furnish the requisite information within 33 days. A letter of the appellant is also prepared furnishing information
Yes.
on so and so as
as
half
half-
of the
half-
information is available in Iman also. And he was also informed. But no response have been received from the appellant in
my lord,
that.
that information also not furnished to me, my lord.
Okay, so now you have it, go there, get the half of the information.
I am not claiming for half, my lord. They have to.
But if the other side is not there, how can this court exercise a writ upon a private individual?
Well, therefore, my, as per the definition of public authority, if the authority, the concerned mill,
Authority says we don't have, then what
well,
do
the
you?
concerned authority, concerned mill is running under the control of the Food and Civil Supplies Department. There are so many documents, allotment of food grains to the concerned mill, and they are bound to apply the provision of the act, my lord. And therefore, at this stage, my lord, my humble submission, let them obtain instruction. What is the present tense? Well, there are certain irregularities, therefore I have submitted the application. For last so many years, they are not properly maintaining their document.
Issue notice making it returnable on 13th of November 2024. Mr. J. Hendrick appears on behalf of the respondent number 1
to 5.
to 5. To stop taking into account that the respondent numbers 1 to 5 are duly represented, extra copies of the petition be served upon them within 3 days. As regards the respondent number 6, steps be taken by way of registered as well as usual. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not providing the information as sought for by the order sought for by the application dated 22/3/2023. In spite of the fact that there is an order passed by the State Information Commissioner on 3/2/2024. The respondent shall bring on record their stand by filing the affidavit on or before the next date.
File your bless.
May I please, Your Lordship? My lord, this case, petitioner before your lordship for cancellation of PDF license of the cooperative society, as well as, my lord, the order passed by the commissioner and secretary upon receipt of the representation of the petitioner at page 62 is the, my lord's order, communication, my lord, not order. This is the communication by which, my lord, after receipt of inquiry report, page 62, my lord.
What are the impugn orders you are challenging?
I am challenging the, my lord, cancellation order at page, my lord. Page 34. While passing the cancellation order, the authority in Food and Civil Supplies Department has not, my lord, given a hearing to the petitioner society, because after suspension of the license of the petitioner society, my lord, the ex-secretary was, my lord, replaced by another secretary. And that information was also approved by the DRCS and say page 31. Page 31 is the, my lord, approval of the appointment of in charge secretary, since the allegation was against the earlier secretary. And pursuant to Annexure 4, page 31, the communication was also made to the, my lord, Food and Civil Supply Department, page 32. Serial
So you
number,
are saying that this notice, this
My
was done 19/7/2023,
yes,
was passed without issuing notice.
to the, my lord, petitioner society. So the,
No, it belonged to whom?
my lord, belong to petitioner cooperative society.
Huh?
Petitioner cooperative society.
Again, no, whose license it was?
It was the license of the cooperative society. Ma'am. Page, my lord, Annexure 1,
So this license was cancelled.
cancelled.
Page,
Page, my lord, page 34, Annexure 5, type copy.
okay, then,
Then, my lord, petitioner filed a representation before the, my lord, since, my lord, under the act, is the divisional commissioner to whom appeal should be made. This divisional commissioner is not available, and representation was filed, page, my lord, 49, my lord, Annexure 10, before the director.
so you are saying that there is no so cause notice in spite
Yes.
of the 13(3) order saying that there is a so cause notice.
Yes, my lord.
Then,
My lord, I have filed representation Annexure 10, page, my lord, 49, before the, my lord, director, to whom, my lord, and the minister has also ministered to departmental minister, who forwarded it to the commissioner. Commissioner has conducted an inquiry by page 51, Annexure 11, my lord. Upon receipt of the inquiry report, my lord, page 62 order was passed, Annexure 16,
page,
62, Annexure 16. Communication, page 62, my lord, Annexure 16. By the commissioner, my lord. On 6/3/2024.
then,
Then nothing has taken place. My lord, I have also filed, after that also I have filed representation before the district commissioner, page 63. DRCS has also communicated to the district
no,
commissioner.
once the license has been cancelled, Who can allow to, how can a license be again reissued?
Under the earlier, my lord, provision of Assam public distribution orders, my lord, one is to file a appeal before the divisional commissioner. So by this time, my lord, divisional commissioner is no more because it was, my lord, by a cabinet decision, it was, my lord, cancelled. So now, my lord, they have to file appeal before the, my lord, commissioner of the Food and Civil Supply Department. So there is a case where though petitioner filed a representation before the minister has forwarded it to the, my lord, commissioner. Upon consideration of the commissioner has sought for a report from the deputy commissioner, district commissioner Karimganj, and upon receipt of the report, my lord, page 62 order was passed, communication was issued.
So there was a direction for reinstating
Yes,
or giving you the fresh license.
fresh license.
Now,
In the
then
March,
also they are not complying.
yes, my lord, from the March 2000, my lord, 24 till date, no, my lord, no compliance. Departmental authority, my lord, Cooperation Department has also communicated with the district commissioner, page 64.
Hello?
For compliance, but nothing has been, my lord, done. And allegation is that, my lord, secretary has misappropriated some, my lord, PDS item. And for the
Who is
savings of,
appearing for FCI? FCS? You are appearing
Not-
to notice making it returnable on 28/10/2024. Mr. J. Hendrick accepts notice on behalf of respondent number 1, 2,
1 to 6.
3. Then district commissioner also.
yes. He's
1
also-
to 6.
So then here the district 1, 2, and 3 is directing the number 4 to comply, and the 4 is not complying for which he has come.
Yes,
Now you are, can you appear for all? That is why he has come.
yes, ma'am. At this stage, madam, I am not about against the cancellation because some consideration is made, my lord, by the commissioner. He is the authority. As of now, he is the competent authority. Please speak.
Well, we will make it short notice, then as you are appearing for everybody. Get a short notice. Issue notice making it returnable on 30/9/2024. So Mr. J. Hendrick appears on behalf of the respondent numbers 1 to 6. Mr. So-and-so appears for respondent number 7. As the respondents, all the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. From the materials on record, it transpires that the petitioner herein was a licensee under the Assam Public Distribution. What is that order name?
My lord, 1982.
What is that? Assam Public
Distribution articles order 1982.
1982. Hereinafter short referred to as the order of 1982. This license was suspended by an order dated 13/3/2023.
Yes.
It is the further case of the petitioner that without issuance of a show cause notice subsequently by an order dated 19/7/2023, the license of the petitioner was cancelled.
Yes.
Under such circumstances, the petitioner has duly approached the commissioner of the Commissioner of
Food and Civil Supplies and Consumer Affairs, Assam.
Consumer Affairs, who is the appellate authority against the cancellation made under clause 15 of the
Under section, yes.
order of 1982. Thereupon, by an order dated
And that 24/3, so
by an order dated
6/3/24.
6/3/2024, the Commissioner, Food, Civil Supplies and Consumer Affairs and Legal Metrology, Assam, who is the respondent number 2, have directed the District Commissioner Karimganj to take necessary decision regarding reinstating issuance of fresh license to the petitioner, taking into account the convenience of the, what is this, FPS?
Fair price show.
fair price shop dealers and feasibility. The learned counsel appearing on behalf of the petitioner submitted that pursuant to the said order dated 6/3, pursuant to the said communication dated 6/3/2024, the petitioner had submitted numerous representations to the respondent number 4. However, no actions have been taken. It is under such circumstances the petitioner has therefore approached this court by filing the instant petition. Mr. J. Hendrick, who appears on behalf of the respondent number 1 to 5, shall obtain necessary 1 to 6 shall obtain necessary instructions from both the Food and Civil Supplies, Consumer Affairs and Legal Metrology Department of the Government of Assam, as well as the District Commissioner Karimganj, as to why the directions the order communication, the directions so issued in the communication, as to whether the directions issued in the communication dated 6/3/2024 by the respondent number 2 have been adhered to or not. If not, why so?
Obligation.
What is this?
My period is limited, Your Lordship, regarding
What?
limitation.
Delimitation.
Your Lordship, page 140, and it already did.
115.
My village name is Athaguri, Your Lordship. It is falls under Kwang Gaon Pansayat. And as per particular notification also, my village is falls under 89 Kwang LS.
Yes, what happened?
No, it is not
The
correct.
section here where unanimously shifted to different LACs, considering the yes. So this is written by the AR to the Chief Electoral Officer. Then what happened?
No action has been taken. place
This
there.
was written subsequent the publication of the final draft of the delimitation information. Yes, the draft was published on 20th June 2023, Your Honor. Thereafter, it was fixed for objection and hearing on three dates, Your Honor, which were 19th July to 21st of July of 2022. In between these days, the petitioner were required to file their objection as regards if they have any grievances regards the draft delimitation exercise, Your Honor. Whereas, as of I could see from the petition, because I had received the petition just now, Your Honor, they have not filed any representation to the election commission and expressing their grievances that their village has been wrongly shifted to a different constituency, Your Honor. However, only after publication of the final draft, that is on 11th of August 2023, they have submitted their petition to the Deputy Commissioner on 4 November 2023. That is in page Annexure 5, page 126. Your Honor, as per the law, Your Honor, once the Delimitation Commission exercise has been finally drafted and published in a Gazette notification, Your Honor, that becomes final, Your Honor. So now
No,
that cannot be.
this determination notification, Your Lordship, it is in our favor.
Huh?
It is in our favor.
Who is in your favor?
This is determination notification, Your Lordship, 11 August 2023,
Page
page, Your Lordship, 93.
90.
93. We start from 93,
This is the final lead.
That's the part.
final. And Your Lordship, relevant portion, page 115.
That is equal to 89 Kwang LSC, Your Honor.
Kwang LS,
115.
115.
Then
Then Your Lordship, 89 Kwang LSC area, I am reading, Your Lordship. Borbora Development Block,
we are concerned with which one?
Kwang, Your Lordship.
Kwang ZP, Your Honor.
Kwang GP,
Kwang, you want it in which place?
They want under 89 Kwang LSC,
Kwang LSC.
but now it has been shifted to 91 Ting Kwang LSC.
By Unidas,
Now it has been put out there in 91.
91, you know.
no, I.
Oh, Kwang.
Kwang.
Moran Town, Kwang Development Block part. Now you belong to which part?
Kwang Gaon Pansayat. It is falls
Who
under.
are you? Radhesham Karmakar, Anil Buraguhai, Prasad Iman, Kurmi, so and so. So you want it where?
Our village is Athaguri, this falls
The
under
inclusion
Kwang
of Akabari village in Kwang Gaon Panchayat
Gaon.
under 89 instead of, why?
Yes, your village, our village is
Now,
falls.
in this, as per this final order, where is it?
Yes, but this also Kwang, you also Kwang.
What?
Because our village name is not there, you also Kwang Gaon.
Then why are you approaching?
No, after that, the publication, the list, election, your list. After that, we have inquired into matter that by erroneously, my village is shown as against Kwang Kololwa Gaon Panchayat. It is falls under 91 no King Kong Gaon Panchayat.
What? Yours is which Gaon Panchayat?
Kwang Gaon Panchayat, your lordship.
No, instead of Kwang Kulua Gaon
It
Panchayat.
is shown as Kwang Kololwa Gaon Panchayat by erroneous report submitted with you, that's right. Kololwa
It's
is a
difficult to
village.
understand.
Yeah, yeah.
Village in Kwang Gaon, directing the respondent authorities to inclusion the Akabari village in Kwang Gaon Panchayat under 89 number Kwang LAC instead of Kwang Kolua Gaon Panchayat.
Kololwa.
You are concerned with Akabari village
Atabari.
specifically. Now,
One village.
where is it mentioned that it is there in the other one?
The page 115, village is not there. It is Kwang Gaon Panchayat, Kwang under Kwang Development Block.
Kwang Kolua.
Kwang Khulwa is there.
No,
Kwang
it is
Kolua
excluded.
Gaon Panchayat. Kwang Kolua Gaon Panchayat, your village is now brought under Kwang Kolua Gaon Panchayat.
Yes, this is the grievance, our grievance is there.
Then,
It is falls under Kwang Gaon Panchayat, but they have wrongly erroneously, it is falls under Kwang Kololwa Gaon Panchayat.
so this has nothing to do with the delimitation.
After the demolition, well, Totalis has published it. And Totalis has published page 2024 election, your lordship page 55.
Hmm.
Our village shifting to 91 Tingkong Gaon Panchayat, Tingkong LSC. your lordship. Originally, it was 115 Moran LSC, now it is 89 Tingkong LSC. And page 18, I have annexed the Totalis of 21. 2021, page 18. Earlier it was 115 Moran LSC, now it is renamed as 89 Kong LSC. And page 55, voter list of 2024. My GP is still, our GP is still is 89 Kong LSC. But my village is erroneously shifted.
As per page 140.
Now, this is done before elections.
Before election.
And this notification came on 11th of August. Then does this district commissioner has any business to write all these letters?
We have approached because there is a mistake. But we have after.
How is it a delimitation exercise being cured if there is a mistake?
Because as per section 8A of the Representation Act like 1950 or not, clause 5, it is specifically mentioned that they have to file the objection before the election commission, Your Honor, not before the district election officer. Then after the, if I could read, Your Honor. Section 8A your specifically says, Your Honor.
Hello, we do one thing. Election commission is on home and political. Why are you making home and political? A party? What is the necessity? Huh? You notice making it returnable on 20/11/2024. Mr.
Yeah, I think corresponding
A.
1 and 4.
appears on behalf of the respondent number 1
And 4.
and 4. Who appears for state? No, State Election Commission, there is one, na, somebody.
Rakesh Dubey, R Dubey.
Is there?
I have not seen today, Your Honor, but
Do you serve a copy?
he has been served a copy, not to me, Your Honor. I have not received a copy. Copy has been served to R Dubey, Your Honor. So I
His
have-
name has been shown.
No, Your Honor.
Not shown.
Okay, sir.
Mr. J. Hendrick appears for the respondent number 5 and 6. 6 also? 6. Taking into account that the respondent numbers 1, 4, 5, and 6 are duly represented, extra copies of the petition be served within 2 days. As regards the respondent number 2 and 3, you appear for 3 also, no? 3 variety, would it? J. Hendrick for 3, 5, and 6. As the respondents numbers 1, 3, 5, and 6. 3, 4, 5, and 6 are duly represented. Extra copies of the petition be served upon them within 3 days. As regards the respondent number 2, it has been informed that there is a standing counsel. Which the petitioner is given the liberty to serve and is directed to effect service of notice upon the respondent number 2 through its standing counsel. The case of the petitioner herein is that the petitioner village, namely Atabari, Gao, pursuant to the delimitation order dated 11/8/2023, have been included wrongly in 91 Tingpong LAC, showing it as it falls under Kuang Gaon Panchayat. Whereas, as per the petitioner as well as the communication dated 23/11/2023 issued by the District Commissioner cum District Election Officer Dibrugarh, there was a mistake in as much as the petitioner's village ought to have been brought within the ambit of 89 Kuang LAC. The respondents are directed to file their affidavit, bring on record their stand by filing their affidavit on or before the next.
The petition, within the petitioner's residential areas, my lord, consent to establish a tea factory was given. Your lordship will find it at page 32. Then we filed, my lord, representation complaint. The report was submitted at page 49.
What do you want now?
My lord, now notices to go.
You,
They will
no,
find
okay,
it in the-
you,
appeal is pending.
you only, huh?
Appeal is pending against the, my lord, consent to that, again, because they have withdrawn. They've given the consent to establish, then we file complaint. And the report is there, report says within 200 meters, the residential areas are there. So you have not given affidavit or clarified the matter. So therefore, they have withdrawn the consent also. Then again, my lord, subsequently, they have again given the consent to establish.
To whom?
To the petitioner, to the private respondents, only on the basis of the order passed by the High Court, on page 53, because consent to
Page 50, 53.
53, he challenged the consent to
Shall not be a bar for the respondent to
Yes.
redress the
basis of that.
grievance of the petitioner in accordance with law. So you want a similar order like this? The last portion?
56, your lordship will
No,
kindly
you
say.
say, na, because pending disposal of the
No, that is-
petition, let the appeal be disposed of.
No.
You say so.
Because of that, because Malal, after this, Malal, they passed this order at page 56.
Uh,
The lordship will kindly see where is that residential area, the report has gone. They have not taken into consideration. The appeal is pending, let the appeal, so they have to bring information as regard what has happened to the appeal. So at this stage, Malal, I pray your lordship will issue notice and consent to establish will be subject to the outcome of the court order.
Now they are running.
There,
It's a tea company.
tea
Well,
factory.
who are you to object?
My lord, we are residents of that area, my lord.
So?
Within the residential area, tea factory has been established. And there is a school, there is a mini hospital is there, sounds are there, it is very difficult, my lord. They cannot give consent to establish within the residential area. In their own report, it says, page 49, your lord. Report says,
Residential area?
yes, completely residential area.
Where is it? How?
Page 49, your lord.
Show me where it is being shown as residential area, village. Village is being shown as a residential area.
This is, my lord, your lordship will consider that page 49.
I have heard in the state, in the towns and cities, there are
But in the,
various places found out nomenclature as residential, industrial and all these things. But in a village, where is it?
well, village also, my lord.
Under
if there
what
is a
law? Residential?
Residential areas are there, you are not, the authorities are not supposed to give consent to establish a factory there.
Okay, where is the
There is no-
residential area?
Self, my lord,
Show
therefore we
me
have
that
filed a
your
complaint.
area is a residential area.
We have submitted representation,
No, representation does not show that it is a residential
they
area.
themselves found, my lord, in their
Who
report.
says?
They themselves found, page 49.
They say. They
Page
cannot
49,
say now whether the
the
district
authority.
administration or anybody has said that
Authority,
this
my lord,
village
they-
is a residential. Because this will have a far-reaching consequences. Tea factory. I would have understood the other
page 49.
factories.
In pursuance to the letter received from the circle officer so and so, and as directed by the regional executive engineer, a fresh visit has been made on 14/3/22, and the report says it has been observed that residences are at a distance of 200 meters to 1000 meters from the unit as stated in the complaint letter. One private school and health sub-center are observed at a distance of so and so. So remarks and comments, my lord? An affidavit has been submitted to this office wherein public from locality have expressed their support in favor of establishment.
When
of
did
the
you file an
businesses.
appeal?
My lord, appeal were filed on, my lord, 22/6/23 at page 79.
Before whom?
Before the appellate authority under the section 31 of the Air Prevention and Control of Pollution Act.
Okay, then what happened?
This appeal is pending. They have not disposed of the appeal. We came before the court and court directed, my lord.
Who is the appellate authority?
Appellate authority is page 79.
Pollution Control
Appellate
Board.
Authority Pollution Control Board, Assam, Navani. At this stage, my lord, the Pollution Control Board is here. Let them take instructions.
In the appeal, are these people a party?
These people are not party.
Huh?
A private respondent would be a party.
The private respondent is not a party.
His name is there, Pakwal Tea Company is there, because we filed an appeal, my lord, it is not, that particular thing is not there that you'll have to write like court order and all. They will send notice and all. If this appeal is dismissed, my lord, we'll have to go to the green tribunal.
Fantastic, go there.
So therefore, the appeal, what has the appellate authority done, my lord? This is what is, because during the pendency of the appeal, the consent to operate has been given.
Consent to operate was
Operate.
given when?
When it was given on, we filed an application on, my lord, 19/4/24, my lord, RTI reply has come that we have not given the consent to operate. 19/4/23. Now subsequently, we find on 18/3/24, my lord.
This is
consent
given
to-
subsequently.
Subsequent. no,
Are you
before.
challenging this 18/3/2000? 18/3/24, you can challenge it before the appellate authority. Why you are not challenging that?
Appellate authority, we have filed, my lord.
No, that is against 1911/2022. Not
Right.
against 18/3.
No, 18/3 to consent to operate, but even the consent to establish is there, consent to, we can add it subsequently.
Why you not going there? Why should we entertain writ petition like this?
Appellate authority that against the order of consent to establish what they have done.
Whatever may be, that is another
that is
thing,
not
but
in-
here, why have you not challenged 18.3?
No, 18T24 will automatically come in for if, consent to
18.3, how can you
establish both.
challenge 18.3 when there is an appellate forum?
My lord, we have said so, my lord.
Against the consent to operate, there is an appeal lies, Mr. Borua.
The consent to establish only any order passed.
Any order which they
Any
are,
order
So
passed,
consent to operate will also be an
yes,
order.
it will be also. And in
So
fact,
an appeal lies, why should we entertain?
the
I'm not
very
there, my
petition
lord.
is start.
What I'm saying.
No
my
to
lord, against the
26.
court- Against the consent to
So
establish.
you have already approached and look at your prayer. The first portion you challenge this, the pending, you said that kindly dispose of the pending or yet there shall not be a bar for disposal of the appeal.
Yes.
So you want all the avenues before this.
Not all.
Then
the-
why are you not filing one green tribunal also? Let all these there
Against the
and
order.
one also against this in the writ appeal. Then everywhere you are moving. Move a
Everywhere,
green
my lord, I
tribunal
came
also.
before the court because my lord, consent to establish was given, my lord. At
So
this,
against this consent to establish, if as regards consent to establish, consent to operate, is there an appellate forum or not?
again, if consent to establishment goes, my lord, then my consent to operate will also go. I will definitely.
So we
add
will
consent
therefore
to-
restrict your writ petition only to the extent of
No, no,
appeal,
I,
nothing more than that.
now what I am saying, my lord, what my submission is,
Hmm.
my lord, what they have not acted on the appeal.
So we'll ask them to act on the appeal,
Yes,
matter finished.
yes. That will do.
Because this court is not entertaining this
No,
18.3.
it's all right, my lord. Your lordship, that line is different because the consent to, my lord, the appeal has not been disposed.
Okay.
Because
Heard
all these
Mr. B.D.
persons, my
Das, the
lord,
learned senior counsel, assisted by so and so. I've also heard Mr. S. Bulwa, the learned counsel appearing on behalf of the
Respondent 5 and 6.
respondent numbers 5 and 6. Mr. A. Kulta appears on. You appear for one also? No. No, he. Pollution?
That's the forest department.
Okay. No forest department. Today I saw one forest department council. Yes, I. Thakur is there, huh?
Yes.
Okay, Mr. I.
Very good.
Thakur appears for respond number 1. Mr. A. Kulta appears for respond number 2 and 3. Mr. J. Hendik appears for respond number 4. And Mr. S. Buru appears for the respond number 5 and 6. Taking into account that the order which this court proposes to pass in the instant proceedings, this court, the presence of the respond number 7 is not required. Full stop. The instant writ petition has been filed challenging the order dated 18/3 the consent to operate granted to the respondent number 7 dated 18/3/2024. Taking into account that it is an appeal lies against the said order, this court is not entertaining the instant writ petition as regards the challenge to the consent to the operate dated 18/3/2024. Be that as it may, it is seen that against the consent to establish so granted to the respondent number 7, there is an appeal being filed to the appellate authority. That is the appellate authority under the appellate authority of the pollution of the respondent number 5. Respondent number
5.
5.
5 is the chairman.
Oh, no, 5, of the Pollution Control Board of Assam, of the State Pollution Control Board, Assam. Against
against
It
the
is the
order of consent to establish dated 17/7/3/22. That appeal is against that. 7/3/22, which was
No,
withdrawn.
no, against 1911. It is the grievance of the petitioner that the said appeal was filed as on 22/6/2023. However, the appellate authority of the Pollution Control Board, Assam, have not disposed of the said appeal. This court have inquired with Mr. L. Burua, the learned standing counsel, appearing on behalf of the respondent number 5 and 6, as to why the said appeal have not been disposed of. The learned counsel submits that this court may pass appropriate directions for the purpose of disposal of the appeal within a time frame. He, however, submits that while disposing of the appeal, the appellate authority has to hear the respondent number 7. Also, taking into account the above submission of Mr. S. Burua, the instilled with petition stands disposed of, directing the appellate authority under of the state of the Pollution Control Board of Assam to dispose of the appeal filed by the petitioners against the order dated 19/11/2022. And the said this court, however, makes it clear and to dispose of within the time frame, and preferably within a period of 4 months from the date of the and preferably within 4 months. This court further directs that the said appeal shall be disposed of shall be disposed of after due consideration, after putting the respondent number 7, who is against whose consent to establish the appeal has been filed. With the above directions, the instant appeal stands disposed. The instant petition stands disposed. Be that as it may, for the sake of clarity, this court makes it clear that this court is not interfering with the order consent to operate dated 18/3/2024 on the ground that this court is not entertaining the petition. However, the petitioner would always be at liberty to challenge the same in accordance with law.
But they will dispose of the appeal within
4 months. First of all, you don't have a right. This is the way here. This is residential. You go to Upper Assam. Everywhere you have a tea factory. Everywhere you have a nearby school.
got some case laws which is to different level. We have not challenged it, your lordship. Yeah, well, 4 months, I think this, they should hear it earlier.
We make it even by making it 6.
After your lordship. In the, at page 37, they are discussing about proposed notice, but my lord, we have not seen any proposed notice as contemplated under section 73(1).
A similar issue also was fixed on 17.
My lord, in fact,
On
my
9
lord,
it came up.
in fact, Jharkhand High Court also, my lord, came to the conclusion, my lord, summary of proposed notice cannot be said to be so-called notice, your lordship, under section 73. Your lordship.
When you have issue notice,
Yes,
the matter?
17/9. 17/9.
Moreover, my lord, this plea or because the order was passed after the time limit was, my lord, that plea I have taken, my lord. No notification from the state government has been issued, my lord, under section 68A, 168.
Why we approved so late?
That is true, my lord. Time is there, lordship. It was
What time?
Order was passed on, my lord.
31/12. Order has to be filed, repeal should be filed within 60 days.
But when the order is passed without, my lord, read by
principle of natural justice and my lord, barred by limitation only on that ground, my lord. In my humble submission, your lordship, ma'am.
There cannot be a bar of limitation insofar as the central aspect is.
This is state.
It can't be, it has the CGST.
No, my lord, it is.
Yes,
state.
kindly see, and page 33.
My lord, don't, if you know, Assistant Commissioner of State Tax, page.
Aha, it is being done by them. It's a different aspect. They are doing it. They have been given the power to do it. But the assessment has two aspects. One is the SGST and another is the CGST. Now, how do you take care of the CGST? How can it be said to be barred?
My lord, subsection 6, section 6A says, my lord, if the state, because when the authority has, my lord, because this is composite, your lordship, and once one authority has initiated, meaning there, my lord, it is the consent of CGST also, your lordship. Or when that authority has not acted in accordance with law, my lord. For that, my lord, that because if the central GST goes, my lord, state also goes, your lordship. In the central order, if your lordship finds that this is hit by principle of natural justice and violation of, my lord, section 73 and 75(4), state also go, my lord. Same in the case of state also, if the state as doing the assessment and all, issuing the proceeding, and it is not in accordance with law, my lord, and the consent is there because this is a composite act. In my humble submission, that on that ground, my lord, it cannot be said that there is a CGST consent of is not there. Since the consent has been given and this act was enacted, composite act, your lordship, so far as goods and service, your lordship. So in that case, my lord, when the state is doing and center has consent and given authority to do on their behalf, in my humble submission, it cannot be said because.
So when the center allows them to do, this is the component of the CGST. Is it under the AGST or the CGST?
My lord, they are doing under the AGST Act.
This CGST is being taken under what provision?
My lord.
CGST is taken under what provision?
My lord, this is after amendment, my lord, the composite act was enacted, my lord.
See, when section 246A, article 246A came in, both the state and the center have been given, what is the term called? It is no longer concurrent. It is now called simultaneous, no? What is that?
Not concurrent.
There's a term used out there in VK footsteps. Now, both of them are being given the power to exercise, realize debts. On the basis of Article 246A, CGST Act came, AGST Act. AGST element, that is the SGST, is being done by, is taken on the basis of that element. CGST element is taken on the basis of this element, CGST. Okay. Now, if the CGST thinking is taken on the basis of CGST Act, where there is an extension of the power under section 168A by the notification of the 56, then in that regard, so far as the CGST element is concerned, that will be proper. SGST may not be there, but the CGST would be proper. Now, if the CGST is proper, here 6.2 gives a delegation of the power to them, which should have been done by the central authority. It is being given to them. So, by virtue of section 6 of the CGST Act, read with notification number 9 and 168A, they have the power insofar as the CGST element is concerned. May not be in respect to the AGST if they don't have a notification. How do you say that?
Like in CST, my lord, when the interstate trade and commerce authority was given to state government, whatever they are done, if it is not in accordance with your lordship, their decision that I will place my on 17. That was second,
No,
that
no.
act was also.
What they have done, that CGST, not CGST, CST. CST power to make the assessment under the CST was given to the state authorities. Interstate Trade and Commerce sales, it is being given to the CGST. The intrastate was to be taken up by the VAT. Now, when the VAT is being done, VAT may constitute the interest, penalty and all, which is however not there in the CST.
Right.
So under such circumstances, can you say that the authority under this act, who is exercising the jurisdiction, which is a person who is being appointed under the VAT, but who have been delegated the power under the CST, would have the jurisdiction to impose interest on the CST?
Because
No.
in the CST, there is no provision. Your lordship.
Absolutely. So it has to be who exercises the power is not material. It is a delegation of that power. The question is whether could that power be exercised by the delegated authority. Now here is a case that the delegation has been done by a statute. So on the basis of that, they are doing it. So far as the CGST element is okay. Maybe the AGST is bad.
So far as CGST also, your lordship, since no so-called notice has been issued.
That is another aspect of the matter.
Limitation by lordship is there.
So far as
So you're saying about the
73,
limit-
that I will examine around 17, I will try to apprise your lordship. But if the main route is manual issuance of so-called notice, the proceeding, because subsection 7 of section 75 says no demand can be more than what as per the so-called notice. If there is no so-called notice, my lord, where is the question of demand as per section 73? And my lord, regarding summary of so-called notice, my lord, as a persuasive purpose, my lord, division bench of Honorable Jharkhand High Court says, my lord, that summary of so-called notice cannot be treated as so-called notice as contemplated under subsection 1 of section 73. And my lord, it was quashed by there also, my lord, Jharkhand JST was there, your lordship. So far as that CGST part is concerned, my lord, I have to examine. But here, the very initiation is, my lord, issuance of precondition is issuance of so-called notice. If that preconditions are not fulfilled, my lord, 73 is the fruit of that, my lord, initiation. But in my humble submission, my lord, everything will go because CGST has not done. State has not issued any notice, no opportunity of being heard given to me. Subsection 4 of section 75 says before passing any adverse order, my lord, an opportunity must be given to me, your lordship. And Honorable Chhattisgarh High Court also held that subsection 4 of section 75, it is a statutory provision and natural justice cannot be violated. So, my lord, on that score also, so far as, my lord, limitation.
So when a technical aspect, like yesterday, there was one judgment which I passed. If it is on a technical aspect, I'm setting aside on the ground that the suppose is not there under 142, rule 142, 1. This is the rule 142.
Rule, it is summary of so-called notice.
Read that, 142, 1.
Fine.
Read it. You don't need the Jharkhand High Court for that.
My
Read it, 142, 1.
The proper official shall serve along with the notice issued under section 52 or section 73 or subsection 74 or section 76 or section 122 or section 23 or 124 or section 129 and 30. A summary thereof electronically. That's
So therefore, what is required is to issue a notice along with the summary. And then as per 142.2,
Right.
142.2,
where before the service of notice or statement, the person chargeable with tax makes payment of the tax and interest in accordance with the provisions of subsection 5 of section 73, or the case may be tax, interest and penalty in accordance with the provisions of subsection 5 of section 74, or where any person makes payment of tax, interest or penalty, any other amount due in accordance with the provisions of the act, whereon his own ascertainment or as communicated by the proprietor under subrule 1A, he shall inform the proprietor of such payment in form so and so, and proprietor shall issue an acknowledgement accepting the payment made by the said person in form GST.
So therefore, the second part, that is annexure 2, is that.
This is an
Annexure 3 is the order. Now, in another matter of Mr. R.S. Mishra, I will, 142.5,
a summary of order issued under section.
there has to be an order. A summary of the order is to be given in DRC 7. So this is DRC 7. There has to be an order. There is no order or whatever may be. So what is required to be done is, this is required to be set aside. But the period from the date of the notice, summary of the year which was given, till date, has to be excluded while computation of limitation. It's a different thing. For AGST, they cannot, because they don't have an additional thing. Because you see, if you see section 73, it says 3 years from the date of submission of the return.
Right.
Isn't that
Where
73.1?
where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized for any reason other than the reason of fraud or any willful misstatement or suppression of facts to evade, he shall serve a notice on a person chargeable with tax which has not been paid or which has been so short paid, or to whom the refund has erroneously been made or has been wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in notice along with interest payable thereon under section 50 and a penalty leviable under the provision of this act or rules made thereafter.
73.2?
The proper officer shall issue the notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10 for issuance of.
Now subsection 10 is 3 years.
The proper officer shall issue the order under subsection 9 within 3 years
From
the date of furnishing annual return.
So from the date of when you have furnished the annual return, it is 3 years. So this period is being given from there. Now in view of section 75.1,
where the service of notice or issuance of order is stayed by an order of a court or appellate tribunal, the period of such stay shall be excluded in computing the period specified in subsection 210 of 73 and 2.
so this period is to be excluded if there is a stay. So therefore, in this case, you have approached in the month of September. So therefore, if I am setting aside on the ground of a technical grounds, so the period from that date,
So
from
far
the
as
date of issuance of the summary of year till date be excluded, and they will be then given the liberty to issue a show cause, and thereupon you
so far
reply
as
and do whatever.
CGST component.
You can very well say you cannot now. When you submit a reply, you can very well say that now you cannot do that. Can't you say that? You have not got an extension. The extension is only till there. You can very well say these grounds are always available to you. This is not for the 2026 court. Isn't it? So this is the order I'm going to pass on 17. But today I can't dispose as to without asking them as to whether they have issued a suit.
In earlier one, they have not issued.
They have not. So there I have thought it. They have looked into this provision. This is how it has.
Your lordship is more concerned with about CGST. I think.
No, I'm not
Because
concerned with the
they
CGST.
are-
It is not a question of CGST, but the question is the moment I set aside the entire thing. Therefore, I have been all along asking the question that is it possible that the entire thing will go? Because the power to impose the tax, the power to levy the tax, everything is intact in CGST. However, in SGST, it is not there. because of the fault of the state government. They have a lot of money, so they don't want money. So for them, it is okay. But how do you take care of the central government? The central government can't lose because of their inaction. Because it is an extension being given till 31st of December 2023. So therefore, if it is given, so this period, from that date to there, if they don't do it, that means
As your lordship.
then the central government may, at the time when the amount is to be refunded. See, GST work in that mechanism, na? So on the entire money will go to the central government coffer. They are going to reimburse the state. They will take note of that it is all the fault of the officials of the CGST we have been suffering. And anyways, the Assam government does not require money. They have got lots of money. Isn't that? The Gogoi? Money is not. See? Okay.
17.
Huh?
17.
Issue notice making it returnable on 17/9/2024. What is the other petition number? We'll take it up together.
Yes.
The petitioner, Mr. B. Gogoi, appears on behalf of the. Because actually, you should also make that this CGST also a party because you are not made. But you see, here is the case. This court is have to now look into the interest of the CGST because of the fault of the SGST. The state authorities have made all these problems. We could have done it earlier. Anyways, issue notice making it returnable on 17/9/2024. Mr. B. Gogoi appears on behalf of the respondent number 1, 2, and 3. The case of the petitioner herein is that the petitioner was not issued the show cause notice. In the case of the petitioner herein is that the respondent authorities have passed the impugned order dated 31/12/2023 in gross violation to the mandate of section 73 read with rule of the section 73 of the CGST Act 2017 as well as the AGST Act 2017 as well as the mandate of Rule 142 of the rules framed therein under. The learned counsel appearing on behalf of the petitioner further urged that in respect to the claim, in respect to the demand more particularly pertaining to under the Assam State General Sales Tax Act 2017, the same is also barred by limitation inasmuch as the period as stipulated under section 7310 had expired and there is no extension. So there is no extension in terms with section 168A of the Assam GST Act 2017. On the returnable date, Mr. B. Gogoi shall apprise this court as to whether there was any show cause notice issued apart from the summary of the show cause notice, and further as to whether any order was passed in terms with section 73(9) of the CGST Act 2017 other than the summary of the order which have been uploaded in the DRC 07. List accordingly.
The other case is on the WPC number 3910.
Is the matter along with
391024.
oblique 2024 at 2 p.m. So this is another set which will dispose it upon. This is the manner in which it's been disposed.
One
Okay,
thing,
go ahead.
Lordship, yesterday that matter your Lordship has fixed on 17. But my Lord, the department is giving call to my client for making payment, your Lordship.
Don't do that.
If your Lordship instruct learned
No,
counsel.
this is the order which I am passing. And if you do it, if you have later on I've come to learn that you have done it, then to I finish an entire thing. Ask your people not to do. Yes, what is the next one?
Same, your Lordship. Only 74 order was passed under section.
Order date is different.
Order was passed under section 74, your Lordship.
Oh, this 74. 74 is 5 years.
There I am not disputing. Like limitation, extension of limitation, I am not disputing, your Lordship. But notice was not given, that is there. Without notice, my Lord, they have issued.
Okay, এইটো অকণ বেলেগ হ'ব। এইটো ওপৰখিনি লিখি দিব। এইটো একেই কৰি ৰাখক। খালি সেই তলৰ এইখিনি যে লিমিটেশনৰ কথাটো কৈছো নহয় 168 এইখিনি নালাগে।
The Impune order is dated 28/12.
28/12. Here there is no limitation problem because it is 5 years. 5 or 7 years.
5 years.
The
But here I
limitation-
have taken the plea in that only they have written 74, but virtually this order is under section 73. That I will apply, my Lord.
That obviously without a show cause notice it has to go. But the period also has to be again excluded. That is there. But then also you can very well take the plea to that effect. That I'll leave it to your people.
Fine.
That it will not come under 74, it may be a case under 73.
Deeply obliged.
13.
Yes, what is this?
Letter pertains to the non-payment of compensation matter.
Huh?
Non-payment of compensation matter.
Who has not paid you?
That is the ADC matter. District.
Against the
district
person of
commissioner matter, Dhubri. But the petitioner's land was acquired matter in terms of the LA case number 1 of 2022-23.
What is ROB?
Relay overbridge.
Okay. It's too long a word, no? To put
No,
it
but
in the prayer.
because it is in their order matter. That is.
They may do anything, but for this court, how will the court know ROB what it is?
I was also confused matter.
RO them do. It is under the railway
I'm sorry,
overbridge.
madam. That is the relay overbridge matter.
And were you asking 10% interest?
But if they are not paying matter the timely manner, because
Why?
madam, some of the.
You are entitled to 15. Why you are limiting yourself to 10?
Yes, sorry, madam, yes.
My goodness. So you want to give back the 5?
No, madam.
Whether it is a case of waiver. Mr. Gogoi, there can be a waiver against the statutes.
No, madam.
There cannot be a waiver against the constitutional provision, but there can be a waiver. Are you doing that?
No.
No, we'll take it. The 10% you want.
Paying loss. He is paying loss. Actually.
So then tomorrow, are you not going to have a problem? Mister, I'll pass tomorrow an order. They may file an appeal and say that, look here, we never asked for that. How do you take care of it?
Beyond the payrolls. Beyond the payrolls.
And when was the land taken?
Land taken by the. Eviction case matter. This order was passed matter 13/3/2023 matter.
20?
3 matter.
Okay. Then it is okay. Then it is 9% for the first year. Let it remain. Issue notice making it returnable on. Let's try to find out what it is before vacation. On listed issue notice making it returnable on. Not post, okay, on 30/9/2024. Union? No union. Oh, you are. Mr. K. Gogoi appears for the respondent number 1 and 2. And we appears for 3-4, you have. Miss M. Bormon appears for the respondent number 327. As the respondent numbers 1 to 7 are duly represented, extra copies of the petition be served upon them during the course of the day. The petitioner hearing is aggrieved by the action on the part of the respondent authorities, more particularly the respondent numbers 4, in taking over the possession of the land. Possession, na? Possession of the land belonging to the petitioner at measuring 1 Rupkatha 7 lectures covered by dark number 213 and 214, included in Patta number 166 and 167 at Hakama Part 3 under Bilasipura Revenue Circle. Within the district of Hubli. Without payment of, we are in violation of the, without authority of law, in as much as the petitioner have not been paid any compensation. The respondents are directed to apprise this court on the next returnable date as to whether any acquisition proceedings have been initiated for acquisition of the land of the petitioner, and if so, as to whether any payment of compensation has been made in favor of the petitioner. Yes, Mr. Vartman.
See, here is the case, your lordship, the petitioner society, your lordship. They were in occupation of a 2.8 shataks of land, your lordship, which was allotted to them, your lordship, by the North Kasar Hills District Council, your lordship. And in fact, they have constructed a, your lordship, warehouse in the, over the, on the same sort of land, your lordship. With the funds sanctioned by the authorities, your lordship, the Northeastern Hills Council, as well as the state government.
So your land, which have been allotted to you, have been given to somebody else.
And if your lordship comes.
Where is your allotment?
Lordship, your lordship may kindly come to page 65 for a moment, your lordship. They have admitted this, your lordship.
We
have gone to your lordship, PLS, your lordship. Then there is the proceeding. Page 66, your lordship, first paragraph. Page 66, your lordship, first paragraph, last part, your lordship. Your lordship, this letter has not been, your lordship, served on us till date, your lordship. Only when your lordship this was placed.
Who is this person? Secretary DLSA.
Lordship.
What does DLSA has to do?
Lordship, we have your lordship filed a complaint before the DLSA, therefore, the mutual.
DLSA has no business, no?
Lordship. But why I am showing this, your lordship, that they have admitted there that without issuing any notice, without serving notice, they have cancelled the allotment without even serving that letter.
Where is the allotment?
Your lordship will kindly come to that. Your lordship will get.
Who is the respondent number 2 there?
Respondent number 2 is the North Kasar District Council's Revenue Department, your lordship. In fact, your lordship will kindly come to page 44. This is the order, your lordship, by which land has been handed over to us, your lordship.
Where?
Page 44, your lordship. This is 30th September 86.
Yeah, 44
Lordship.
for
Handing
handing
over,
over possession of the land to the executive officer, wholesale so and so amount. Then,
Then, your lordship, we have constructed the, your lordship, land there, handed over, your lordship.
but which tag, which patta, where, what is there?
Lordship, that
Land belongs to whom?
land belongs to the North Kasar Autonomous Council, your
So
lordship.
where is this land has been handed over to you?
Lordship, this is the land, your lordship will kindly come to page 38, your lordship, where we have made application, your lordship. In
Yeah.
fact, that particular order, your lordship, old order, we could not, your lordship will find, your lordship.
Who is EO?
Page 38, your lordship will kindly come to page 39.
Mhm.
Serial number 5.
Mhm.
This is the land, your lordship. 2 bighas, 6 kotas, 5
Order
kotas.
for allotment of land measuring 6 katha in the extension is awaited. What is this?
Then, your lordship, page 5. This is the letter, your lordship, we have submitted for issuance of periodic patta way back in 1986.
This is a letter written by whom?
Yes, sir. We submitted this application before the
No, where is your allotment?
allotment. Your lordship will kindly come to page 39. Order is not available with right now, your lordship, with us.
Then,
But
it's
your,
not an allotment.
no, your lordship, this, your lordship will kindly see 2 bighas 6 kota, Kasipur village number 6. Then the order is dated 8/8/86, your lordship.
Have been received as a result of the rent of plots cannot be cleared. Then, are you paying any tax?
Yes, your lordship. we
Where?
have
Where is the revenue you are paying?
Revenue, your lordship, that I have not annexed, your
Then-
lordship, but your lordship will
Prepare
kindly,
your matter properly. No case as of now.
no, lordship will kindly see the admitted position is.
I'll show me one document that you are there in this document, in that land. Some official document that this land has been allotted to you.
They have,
Without an allotment has to be there by way of a specific order. Then,
no, in fact, your lordship, that's why I have brought to the record, your lordship, the notice of the DLS, your lordship, the order of the DLS, where they have specifically submitted that they have cancelled the allotment, your lordship, granted in my favor, your lordship.
they must have stated verbally.
No, your lordship, it is recorded, your lordship.
No, that the DLSA has recorded. I'm not on that. But have they stated verbally or is it written?
That, your lordship, that copy,
Get your instruction on that. If
lordship.
it is written, then you have a case. Otherwise, you don't have a case. DLSA order does not become a proof that there is an allotment. No.
But your lordship, in fact, your lordship, over that plot of land, your lordship, we have constructed a warehouse, your lordship. That warehouse,
If that is the warehouse you have constructed,
lordship,
1 bigha 16 lessers is now in the occupation of the other, this joint of Kemprai or so and so. So how is he in possession? By constructing a bamboo hut.
lordship will kindly see, your lordship, the order in his favor, your lordship. That has been issued, and thereafter, your lordship will kindly come to page 57 for a moment, your lordship. This was the letter we have written to the revenue officer, your lordship, North
Page
Qatar,
50,
57, your lordship.
AK Patta to so and
When
so.
your lordship, they
Allotment
started
of land, yes,
lordship.
yes.
encroaching, your lordship.
Iman is hereby allotted you the AK Patta by cancelling the land of State Fed Gudao.
Lordship, that's what.
Long on condition that allotment will not be vacated. And when the authority requires for any purpose in future, moreover, prior to construction, any allotment will inform the owner. Please therefore deposit 1,500 to the office of so and so. But show me somewhere that you may, if you are having your office,
Lordship.
there will be some mention
Lord.
somewhere, some address, something. Show me something to that effect by which this court
In
can help
fact,
you.
your lordship,
How do you identify the state-paid land is yours?
while your lordship,
It may be a thing that the state-paid land is somewhere else.
no, that is not your lordship. That is why your lordship, we have made a specific environment, your lordship, that this was not good.
Okay, you would not, at the end of the day, We will see sometime in 2029.
Your
Okay.
Lordship, that cannot, that may not be done, your Lordship, because ultimately, your Lordship, the construction, what your Lordship, it is not about the
Mr.
land.
Bhattakur, this type of cases is not going to help you out. Anyway, let me issue a notice.
Lordship may, or then your Lordship may do.
And
Fix the
because
matter some
there's no
other day,
document
Lordship,
out there. You want this court to make a fishing and roving inquiry from the NC Hills and ask them to file an
No, your
affidavit
Lordship.
stating as to whether the petitioner was allotted a land.
Your Lordship may kindly post the matter next week, your Lordship. I will in the meanwhile try to collect these documents, your Lordship.
Let me issue notice, you file additional affidavit.
But your Lordship, I will pray for an interim order, your Lordship.
What interim order?
No, your Lordship will kindly.
They are already in
No,
possession.
they are in possession, but that is demolished, your Lordship. That go down is demolished, your Lordship.
But there nobody is there because you see, if you are relying on this particular document,
Lordship.
which is at page 65, kindly see the page 65, the down portion, the portion in the 5 lines from the bottom. 10 lines. The petitioner have submitted that the office of so and so have of late allotted 1 bigha 16 lectures of land of the said 2 bighas of society's land to one so and so by cancelling the land of the state fair. However, the said land was never ever allotted to state fair.
Lordship.
The petitioner has submitted that after the allotment was made to so and so, respondent has been occupying 1 bigha 16 lectures.
Lord.
So this is the entire land which
Lord.
he is occupying.
No, your Lordship, that's.
No, this is your case. I don't say.
No, that is.
And by constructing a bamboo fencing. So that area which is in occupation of the respondent numbers, whoever it is outside the area where you are having his office because that land now only has this.
That is why your Lordship will kindly come to page 69. Your Lordship.
Yes.
Here, your Lordship, we have your Lordship submitted a representation before the authorities, your Lordship, regarding dismantling of Haflong Wholesale Cooperative, Kasipur Gold and some unauthorized person. This is a letter written by the Secretary NC Hills Autonomous Council, your Lordship.
To the Secretary Revenue.
Lordship, to take,
Then
then your Lordship will kindly come to page 70. Take necessary action to inquire into the matter and report in details, your Lordship. Now, if ultimately this is not our private property, your Lordship, this was your Lordship constructed.
so why you are not filing a suit? File a suit. You are who is doing? You see, kindly see who is doing it.
No, your Lordship.
No, kindly see page 70.
Yes, your Lordship. That
See, so and so regarding dismantling of area by some unauthorized persons.
Lordship. But your Lordship, why I am before this?
You say some official of the government, we pass the order.
Lordship.
But how, you want the police to be
No,
protecting
your
you.
Lordship.
Who is going to protect you?
Basis of his action is in your Lordship.
You want a
order.
writ against the unauthorized persons?
No, your Lordship. Prayer portion, your Lordship may go through. Your Lordship will find. I am challenging order of cancellation of my allotment as well as your Lordship.
First of all, their order is not there giving you. How can I stay something which is not there?
Then your Lordship may issue a short notice and your Lordship may fix a date, your Lordship.
Stay and set aside the impugned allotment in so and so.
Lordship.
That cannot be done. It has already been effected.
Lordship.
And she is in possession. The second is to declare that so and so is the lawful owner. These are all pending disposal.
Lordship. No, your Lordship.
My goodness. Yes. Kindly see page
No,
19.
your Lordship, my main prayer, your Lordship may kindly go.
See your prayer, Mr. Bhattakur, pending disposal of the writ petition to declare that Haflong so and so is the lawful owner of the land in question.
That your Lordship will probably, your Lordship will.
I know. Means I may have to talk to my brother who is the portfolio judge of Haflong or the Dimahaso district as to this is the state of affairs. The district judiciary is not working. Otherwise, why are you asking for a declaration from a
No,
writ
your
court?
Lordship, that I am not. Your main prayer, your Lordship may kindly see. I am praying for your Lordship certiorari for your Lordship setting aside and passing the orders dated your Lordship 9/12/2023 and 28/11/2003. This is
What you are asking? That this court should issue a writ in the nature, a writ for delivery of possession?
no, your Lordship.
That is number 2. To direct the response to take immediate to vacate the unauthorized occupation of the land which rightfully belongs to so and so. Who is in possession?
Lordship will
Private
kindly see.
respondent.
Your Lordship will kindly see. Your Lordship. That main petty prayer is your Lordship
course, I assure your lordship.
Number one, you are leaving upside the other.
No, your lordship will kindly, if your lordship says that this goes, your lordship, then ultimately consequential relief, your lordship, that is different matter altogether. But ultimately, without hearing us, it is an admitted position that your lordship, they have cancelled our allotment.
But you see the state, what has been issued to the private respondent.
Lordship.
It has been issued an AK Patta asking them that the moment we want this land, you have to vacate.
Lordship, it is there, your lordship.
That
but
is why 1,500 rupees
Lordship,
total.
I have seen. it. But at the end of the day, we are concerned with that.
Why you are not coming up with a case that how is this possible? This AK Patta, what is this type of AK Patta being issued for 1,500 rupees? For 1,500 rupees, is that the premium of a land?
That is probably your lordship, how they have fixed it.
Now,
your
how did
lordship.
they do so? Is that the, can that be a premium of 1 bigger 16 lectures? No, it can't be there. Then what is the basis on which are these people doing? Challenge those in better terms, not on the basis that you say that you are in possession of the land. Yes, I am in possession. I've been allotted means it is they are in the name of giving it to the state fair, they are taking over our land. We have been in possession of this land for a long time to come. In fact, there is a proposal which is going on for settlement and all these things. But then although without hearing us, which has been also, there are certain documents to that effect. Now they have given it and he is in possession of this. And under such circumstances, they are not taking any action. How this settlement can be made in this manner? And that too at 1,500. This is not the case. Yeah, issue notice making it returnable, no stay business on 4th of November 2024. NC Hills. Who? R.S. Mishra?
RM does.
Where is he? Miss So-and-so appears on behalf of the respondent numbers 1, 2, 3, 4, 4. Mr. S.K. Talukde appears for the respondent number 5 and 6, 5, 6, 7. And Mr. So-and-so, B. Gugoi appears for the respondent 8 and 9. You are PWD? Okay. Taking into account the respondent numbers 1 to 9 are duly represented, extra copies of the petition be served upon them during the course of the day. As regards the respondent number 10, the petitioner is directed to effect service by way of registered as well as usual by taking steps within 3 days from today. You want an early disposal or sometime after 2029?
Early disposal.
Mr. El Botaku, the learned counsel appearing on behalf of the petitioner, submits that the matter requires an urgent disposal and as such, the petitioner may be given the liberty also to take steps upon the respondent number 10 by way of dusty. Accordingly, the petitioner is given the liberty to take steps upon the respondent number 10 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioners are members of a cooperative society. The case of the petitioner herein is that the petitioner number 1 is a cooperative society registered under the provisions of the Cooperative Societies Act 1948, Assam Cooperative Societies Act 1948. The petitioner number 2 to 6 are shareholders of the said cooperative society. It is the further case of the petitioner that in the year 1986, the state respondent, the NC Hills Autonomous Council had allotted a plot of land measuring 2 bighas. 2 bighas, na?
2 big.
2 bighas to the petitioner. And on the said land, the petitioner had set up their office as well as the warehouse. It is the further case of the petitioner that the petitioners were shocked and surprised to come to learn that the respondent and it's, the respondent number the respondent number 4, without giving any information to the petitioner, had unilaterally granted an allotment to the private respondent number 10 of an area of 1 bigha 16 lechas by cancelling the land of the state-fed godown. The learned counsel, appearing on behalf of the petitioner, submits that there was no allotment, that although the order dated date 28/11/2023 states about by that the allotment has been made in favor of the private respondent number 10 on the basis of cancelling the land of the state-fed godown. But in fact, what the respondent number 4 have done is that the land, that the said allotment has been made in respect of 1 bigha 16 kathas, lesser no 16 kathas, of the 2 bighas of land which was actually allotted to the petitioner. Number 1. Full stop. The learned counsel, appearing on behalf of the petitioner, further submitted that this dispute, which arose on account of the unilaterally handing over the possession, unilaterally granting the allotment in favor of dispute which arose, came up before, was placed before the District Legal Services Authority, Dimahaso Haflong, wherein a pre-litigation case was instituted, being case number 19/2024. The learned counsel, appearing on behalf of the petitioner, submitted that the NC Hills or NC Autonomous Council, NC Hills Autonomous Council, that is the respondent number 1 who was duly represented in the said proceeding, have also admitted that they have granted, they have issued the said communication and the allotment in favor of the private respondent without giving any notice to the petitioners. However, in view of the limited jurisdiction available before the District Legal Services Authority, the said case could not be settled. And under such circumstances, the petitioner have therefore approached this court by filing the instant writ petition. This court directs the respondent numbers 1 to 4 to apprise this court as to whether there was any allotment made in favor of the petitioners of the 2 bighas of land as stated by the petitioners in the writ petition, as claimed by the petitioners in the writ petition. In addition to that, the respondent shall also apprise this court as to whether the petitioners were in possession of the said land, wherein the respondent number 10 have been granted the settlement, allotment. Full stop. Anything else you want?
No,
Full stop. The said aspect be brought on record by filing an affidavit on or before the next date. Roving and inquiry.
in the meantime, I will also bring record.
I think this will help you out. This
Okay.
will do.
Briefly apply.
But you can't make those prayers, huh?
Those
This is too much.
I have not done.
Huh?
Yes, you wrote it.
Too much. Yes, you have been evicted.
Lord, I am sought to be evicted, my lord. I am running my shop, my lord, on a premises which has been constructed by the concerned panchayat, my lord. And I have been paying the required license fees also, my lord. And
Where is the eviction notice?
my lord, at page 45, my lord.
Eh?
45, annexure 10.
Where you can inform that below the scheduled government has been occupied by you without a permission, you have been ordered to wear demolishing and immediately after receipt of notice or else you'll be evicted. 31(8). Village or Kake, government class or government reserve. Have you asked for settlement?
No, my lord. Actually, my lord, because my lord, I am running a switch shop over there. I am paying the required license fee and other thing to the concerned
I
panchayat.
am asking you whether you have asked for settlement of
No, my
that
lord,
land.
because that premises has been constructed by the concerned Gaon Panchayat, my lord, under a scheme. And they have provided me the room. And your lordship will find at page 42, my lord. That is constructed under a scheme, my lord. And there the Panchayat has given me the room, my lord. Page 42, my lord. Because I am just running a
Page 42 is a photograph.
yes, photograph of the, because it is name of scheme, construction of market set at 2 number Kaki Sariali near Bipul Hajarika shop. It is my shop, Bipul Hajarika is the petitioner. Under Swencho, name of Swencho. So that set is constructed by the concert Gaon
What
Panchayat,
is this name of AP means?
Ancholik Panchayat, my lord.
Lamding DB.
Yes, my lord.
DB is
Something DB, my lord. Name of AP Ancholik Panchayat and GP is Gaon Panchayat. So that,
is this your shop? Page 43.
yes.
Huh?
Yes, my lord. Page 43 is my shop. And that particular portion.
And you are a tenant.
Yes, my lord. Under the Panchayat authority.
Show me how.
My lord, I have been paying the,
No. How you are a tenant?
not exactly tenant, my lord, because that is a market complex, my lord, that has been constructed by the Panchayat authorities. And I have been allotted this room over there, my lord.
Where is your allotment?
Allotment is not there, but I have been.
Then
I have been.
there
paying
the
license.
question arises. Where is your allotment?
My lord, that is the procedure in the market.
No, you cannot occupy even the PNRD or anybody's place unless there is an allotment.
My lord, I have been granted annexure 1 to 6, my lord. These are the license, my lord. I have been paying the license fees, my lord.
License fee for what?
To the Panchayat authority to run the switch shop, my lord.
This is only a switch shop license.
Yes, my lord.
So that you have a GMC license, would that be over?
No, my lord, that
Yeah.
is not. But my lord, page 42 says, my lord, because it is, my lord, 18 to notice, my lord. I am sought to be evicted. If the Panchayat authorities demand something from me, my lord, then it's okay, my lord, because I am running a shop over the property of the Panchayat authority, my lord.
So the government wants this, they wants to break it. What to do?
Because
The district administration is all powerful there.
Panchayat authorities have.
Panchayat has no business. Panchayat, you see, they don't have any problem. They are, we issued notice to them. Are they a party?
Yes, my lord.
Where are they? They are not there to help you out.
My lord, I have.
Panchayat is not here to help you out. You are Panchayat? Come here. Copy not given, then why you are not giving it to the PNRD?
And the cause is just
Then-
the name is not reflected. on
Whether Panchayat is a party?
Yes, my lord.
Then-
Record number 4, my lord.
How you, without a Panchayat being served a copy? Force? No, Panchayat is not a party.
My lord,
This secretary number 2, Gaon Panchayat, how can it be? Can you take notice on behalf of them? No.
secretary is a government official, my lord.
Secretary number 2, unless you make the department a party, how is it possible?
My lord,
Panchayat is not there.
my lord, secretary of a Gaon Panchayat, he is a government official, my lord. Secretary of a Panchayat, a Gaon Panchayat, he is a government official. My lord, president or other vice president or member, they are not government official, but secretary.
Why you are not making the PNRD a party?
Because, my lord, that particular has been constructed by this concerned Gaon Panchayat, my lord.
So-
That's it, secretary. That's why I have added them as party.
They are not bothered. Are you bothered with the demolishing? They are not.
The secretary.
They are not bothered.
Secretary government.
We direct the eviction to be carried out However, after inquiry with the secretary as to whether it is comes under the government of the scheme, and if it is so, then not to do so. Win-win situation.
And otherwise, my lord, if they.
Otherwise means you have not shown.
Alternatively, my lord.
No, Mr. Bora, where is the document to show that you are the allottee of this particular shop?
Panchayat authorities has not made such allotment, my lord.
Then obviously you have no right. It's somebody else period. You take out your utensils or whatever is there.
My
Take
lord,
out your-
case 43 is a bit.
First of all, if it is a government panchayat thing and the panchayat is not bothered to issue an allotment, the panchayat have disowned this particular property.
No, my lord, it is a page 42.
You
my
cannot
lord.
have that. If it is made under the panchayat thing, it cannot be, can it be possible?
Lordship.
Get a senior counsel of your panchayat. You don't seem to be well versed with panchayat.
Standing counsel is,
Who is your panchayat?
Lordship,
Huh?
ex-doctor will appear in this matter.
Get that person, P. Hendick.
Lordship,
Okay, there's another one, P. Hendick.
Lordship,
Get hold of him.
Lordship, but he's not,
Or as doctor is also.
Not
a
there,
standing
lordship.
counsel.
As doctor, forget about him. He is always busy in other matters. Let us get up Mr. P. Hendick.
but he's not the standing counsel, Lordship.
Huh?
Handic is not the standing counsel, Lordship.
Who is the standing counsel?
Lordship, ex-doctor,
And
Lordship, N. Bora and K. Bora, Lordship. Lordship, he's next in another court, court
they are
number
not
8,
going to
Lordship.
help anything. They will not. Otherwise, you demolish it. You have no business unless you
My lord,
show the allotment.
I will inform them, my lord, your lordship may take up after some time. I will inform them. my
I'll
lord.
take it up at 2, but you have to show me your allotment. Without an allotment in respect to this thing, you have no business. of it. You cannot. Because in all cases, the panchayat, whenever there is an allotment, the secretary or whoever may be has to issue an allotment to you that we are allotting you this particular shop. Isn't that Mr. Sharma? Huh? Otherwise, how can it be? What right you have? They
Without
can
there
very
being
well
an
take it up
allotment,
there.
it
The
doesn't have-
secretary will obviously take it up if it is so.
My lord,
Whether
if
this
the-
construction is being
if
made.
the panchayat authority says that I am a illegal occupier, my lord, then I don't have any.
No, 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 no. Panchayat authority is not. Forget about the Panchayat authority saying anything. Here it's saying here, block number 2, man, Moki, Korea, so and so, class of A. What is your instruction on this, Mr. Sharma? What is your instruction? You are the main person.
Only motion stage, lordship. So
Understood. Motion stage also, you are therefore standing for government.
but today itself, lordship, it is listed, lordship.
Have a call with the circle officer. I'm taking up at 2.
Lordship, I will try.
Let's ask him, what is this business about? Why he has issued in respect to a panchayat shop? So that is his standing. If it is a panchayat shop made under the some scheme of the panchayat, whether it is there or not, why it has been issued? You get a clear picture on that.
Lordship, yep. At two, lordship.
That too.
Lordship.
But then also he has no business of that.
Lordship.
We may ask them not to break it or break it, whatever.
Tablet.
The small query, my lord, the 2 points are required clarification. Yesterday I have received the file, my lord. The first come, first receive is one of their ground, my lord.
The respondent is not represented on the matter. Yes, what is this case?
My lord, here is my lord, their basic claim is that the said was not allotted to them on the basis of first come.
Oh, this one, I remember.
Yes.
This is the case where they first come, first will see.
My lord, just now I came to know because I have gone through the file, that affidavit is also not with me, my learned affidavit is possible to create it. Then the lord said, just fix my lord, Tuesday, my lord, or my lord.
Like prima facie in consonance with affidavit, because your stand in
Yes, sir.
respond number 1 is not in
Yes,
consonance.
sir.
Because on one hand, you said it
Yes,
will
sir.
first come, first basis,
Yes.
and you have rejected
no,
them on the basis of
Right.
merit.
For a question that 2021 there is an industrial policy. Now only one test is required, that whether this checklist applicable after 2021 or prior to that, madam. Only.
I'm not on that, but your affidavit is not clear.
My affidavit says, my lord, that because the advisory committee which has been allotted, my lord, that rules we have followed, my lord. Now their claim is that it is a principle governed that first come, first receive, my lord. Therefore, my lord, they have given just one document there, which is, my lord, part of that their affidavit, my lord, petition number 2. Therefore, I have to get the clarification that whether this checklist was applicable at that point of time of allotment or was it applicable after 2020 industrial policy.
But there will have to be another policy.
Yeah, exactly, my lord.
So you have to bring on
Only
record
then-
that policy.
Because, my lord, otherwise, suppose it would be cancelled, then entire thing will be affected, my lord.
I'm not concerned with others. We are only
Exactly.
concerned with Mr. Sahewala client being evicted.
Only one day, my lord.
Okay.
Not accommodation.
Was Mr. S. Samaria, the learned counsel appearing on behalf of the AIDC.
Yes.
Submits that he requires some more time to get the clarification in terms with the order dated 2/9/2024. To establish this matter again on 28/10/2024.
Well, a direction be given to furnish the copy of affidavit filed by petition number 2, my lord. Where
Filed by
petition
you.
number 2, petition number 2, they have filed an affidavit, my lord.
I give it to you.
If
17.
Directed to provide that up to date circular.
Oh, that matter. My judgment is there now. This is the latest one,
Yes,
as I said, now, and here you kindly see D. If the ongoing construction in restricted zone is not perceived to be a security threat. Do you see?
yes,
In case views of the so-and-so are not required as per the bylaws and construction is not seen as a security threat by here, then a station commander is neither required to raise any objection nor issue an NOC. And the individual should be allowed to construct on his property without any interference. So irrespective of, the main consideration is that whether it is a security threat. Here, what you have done is without considering that aspect of the matter, whether it is a, can you see number B? Where the local bylaws do not require, yet the concern feels that any construction coming within 100 meters. Yours is 50,
Yes, yeah, 60.
60.
60. For multi-story building of more than 4-story 500, radius is so-and-so can be a security hazard. He should refer the matter immediately to the next higher up in the chain of command. In case the next higher is also convinced, then the station commander may convey his objection views to the local municipality or the state government agencies. In case of the municipal area do not take cognizance of the said objection, then the matter be taken up with the higher authorities, if need be, to the IHQ of MOD.
Yes, sir.
You have no business to write or file an FIR or direct any stop to it. You have no business. Where is my judgment?
My lord,
Oh, again after vacation.
I have not brought it.
Then, okay,
My lord,
we'll have it
yesterday
after vacation.
It was fixed for the updated.
I know that
circular.
he has produced, then we'll take it after vacation.
My
You
lord,
don't want an
he's-
money.
He's facing from.
What?
He's facing since 2019, my lord. My client, my lord, he's suffering from since 2019, my lord.
So what?
So, my lord,
You should have been more diligent. I may write it out there that this court have taken the pains of finding out the order and passing an order without the help of the counsel for the petitioner, who have not at all helped this court in assisting this court.
I'm
I
sorry
like
for-
that.
I'm sorry
You
for
want that?
I'm sorry for that, my lord.
Absolutely. You should be sorry.
My lord, as-
You are appearing out here on behalf of a client to plead on behalf of the client, and you don't get that. You ask anybody of them, any of those counsels out there, everybody knows I have passed not 1, 2, 3 orders on this aspect of the matter. That is why I know I asked her to come up with this. And on the last occasion, I told you. That is why I fixed the matter today.
My lord, kindly it may be disposed of on that basis, my lord.
Which basis?
On that basis, my lord, that judgment, my lord, it was already passed. That is
No.
not.
I'll say it. I'll pass it on that basis, but I'll tell it that the client, learned counsel have been of no help to this.
My lord.
Lehok. Although the petitioner is being represented by one Mr. P.K. Das, the counsel. On 27/8/2024, this court have adjourned the matter today on 11/9/2024. And during the course of the hearing, this court have categorically pointed it out to the learned counsel that there are various judgments in respect wherein similar matters have been disposed of. However, there has been no assistance on the part of that counsel. Irrespective of that, taking into account the interest of justice, this court have taken up the matter for disposal at this stage. I've heard Mr. Agayan, the learned counsel, appearing on behalf of the respondents who have placed before this court the recent circular dated 21/3/2023. তাৰ পিছৰখিনি মোৰ সেই অৰ্ডাৰ এটা আছে শ্ৰীমানী খুজি ল'ব মাৰি পেলাই কৰি অৰ্ডাৰ পাইছোঁ This court তলত লাইন আৰু এটা লিখিব This court deprecates the manner in which the assistance is being provided by Mr. P.
I'm sorry for that.
Absolutely. We should impose a cost upon you for 10,000 to the Legal Services Authority. This is not the way you prepare.
And actually, I have seen the order, and as per order, when the updated cycle was called for, and that is why I thought that it will be according to the updated cycle.
Okay. Today, Mr. and Miss Agayan, the learned counsel appearing on behalf of the petitioner, a respondent, have placed before this court the updated circular dated 21/3/2024. The same is kept on record and marked with the letter X. The learned counsel appearing on behalf of the petitioner seeks some adjournment accommodation so that he may be able to go through the same. List the matter after vacations. Yes.
Get the instructions trying to get a printout, but unable to do that. Printout.
So what is the instruction?
May I read, Lord?
Yes.
It is the report of the Latmondal. চক্ৰবিষয় মহোদয়লৈকে লিখা মহোদয় চিঠি নম্বৰ চয়েন্সৰ ওপৰত কাকি মৌজাৰ অন্তৰ্গত 2 নম্বৰ কাকি 2 নম্বৰ ব্লক গাঁৱৰ চৰকাৰী ৰিজাৰ্ভ 241 172 আৰু 265 নম্বৰ ডাগৰ অংশ মাটিৰ মুঠ 14 জন লোকে পিডব্লিউডি ৰাস্তাৰ কাষৰ মাটি বেদখল কৰি দোকান ঘৰ সাজি দখলভুক্ত আছে যাৰ ফলত স্থানীয় ৰাইজৰ বিশেষভাৱে অসুবিধা হোৱা দেখা যায় This is the report of the circle of Latmondal. Thereafter, it's a letter from the circle officer to the district commissioner lordship. উপরোক্ত বিষয় সন্দৰ্ভত জনোৱা যায় যে আবেদনকাৰীগণে 2 নম্বৰ কাকি চাৰিআলি পিডব্লিউডি নিচেই কাষৰ চৰকাৰী ভূমিত থকা দোকান ব্যৱসায় প্ৰতিষ্ঠান কৰা সন্দৰ্ভত ৰাজহুৱা অভিযোগ দাখিল কৰিছে লাটমণ্ডলৰ প্ৰতিবেদন মতে চৰকাৰী গাঁও প্ৰধান সুপাৰভাইজাৰ কাননগুৰ লগত যৌথভাৱে সৰজমিন তদন্তক্ৰমে দেখা যায় যে কাকি মৌজাৰ 2 নম্বৰ ব্লক 1 নম্বৰ গাঁৱৰ ইছামতৰ 242 নম্বৰ ডাগৰ শ্ৰেণী নাই আলিবাগ 172 নম্বৰ শ্ৰেণী নাই গড়কাপ্তানি ৰাস্তাৰ কাষৰ আৰু 265 নম্বৰ শ্ৰেণী নাই আন ৰিজাৰ্ভ ডাগৰ ওপৰত ইয়াৰ লগত সংলগ্ন কৰি দিয়া লোকজনে দোকান বনাই ব্যৱসায় চলাই থকা দেখা যায় মহোদয়ক জনাল যে উক্ত দখলকৃত মাটিৰ ভিতৰত 242 আৰু 172 নম্বৰ দাগ হ'ল ৰাস্তাৰ মাটি আৰু 265 নম্বৰ দাগত ৰাস উৎসৱ পথাৰৰ মাটি হিচাপে চিঠা বহীত অন্তৰ্ভুক্ত হৈ আছে উল্লেখিত লোকজনে উক্ত ৰাস্তাৰ কাষৰ মাটিৰ লগতে ৰাস উৎসৱ পথাৰৰ মাটিও বেদখল কৰি প্ৰতিষ্ঠান আদি চলাই আছে গতিকে মূল আবেদনৰ লগত লাটমণ্ডলৰ প্ৰতিবেদন সংলগ্ন কৰি মহোদয়ৰ জ্ঞাতাৰ্থে আৰু বিহিত আগবঢ়োৱা হয়
So it is a PWD road.
Lordship.
242 is PWD and 265 is specifically reserved for Rakmondo.
Lordship. It's a community hall for this Ras Utsav, Lordship. That printout is there, Lordship.
And Mr. Doctor, what is this type of allotment? He says about, see page 43. He said this is the house.
It looks like, my lord, these are constructed under some scheme, my lord. But those were approved by the Gram Sabha only, my lord. Thereafter, as per it's showing, my lord, 14th Finance Commission 2017-18 scheme.
So can they construct on roads land? It will be reserve loan.
That identification we cannot say directly, my lord, because the circle officer can.
Circle officer says that it is on PWD road. The road side.
Near the road.
So under such, these roads, obviously they can exercise powers under 18(2). Secondly, when you construct these type of things, that if this is done under the PNRD, isn't there the requirement of an allotment to be made in respect to this particular shop?
That is actually required, my lord.
That is the requirement.
Yes.
If it is not given, what right does that person have?
Normally, what happens, my lord, this kind of schemes for development of some markets, maybe wrongly they have identified this as a PNRD market, maybe, my lord, because it's upon the Gram Sabha, they have decided, my lord. We cannot say that it is government or not, my lord. That is our problem, my lord.
The Gaon Council also cannot construct over the PWD road.
They cannot. They cannot.
It is near PWD road, my lord.
No. 242 is PWD road.
Yes, Lordship. That this letter is before your Lordship.
242 is
And 172 it's a PWD road. 265 is in the name of the Rak Mahotsav.
so there. How can you construct? These are specifically reserved.
May I suggest one thing, my lord? May I suggest one thing, my lord? It looks like, my lord, it was started, my lord, on with some complaints, my lord. So Lordship may direct the circle officer along with the PNRD department BDO at least, my lord, to verify and evict, my lord, if they are illegal.
Now, but if it is specific, these land are specific. The building or any building is standing over PWD road
That cannot be sustained.
or even in specifically reserved areas
Yes,
for Rak Mahotsav or anything.
my lord.
There cannot be any
yes,
construction
that-
even by the Gaon Sabha also. They have no business to do that. They
Yes,
cannot
yes.
go
That is-
against the rules. So under such there is no right. Will therefore I will
I'm
do.
just only saying.
No,
my lord.
that I will
So,
direct.
so that, my lord, if some fault in our department is also there,
Hmm.
they can go to that aspect.
Yes, they
That
can
is
look
why.
into it. Will issue notice. Will issue notice to that effect,
My lord.
and I'll permit you to carry on the eviction, provided it is a PWD road and specifically reserved for Rak
Yes.
Mondolan.
She may direct the.
And that should be
petitioner.
done in consultation with the BDO.
Lordship may direct the petitioner to implement the video and see as a party.
Not necessary. I'll pass the order on
Right.
the basis thereof.
Right.
I'm not concerned with the secretary. Secretary has no
Yes,
business.
that you don't
He cannot construct whereby. First of all, he has not shown any allotment.
Yes.
Without an allotment, they cannot be. Merely taking the some license from this the tax collector does not give him any right.
Lordship is very much correct.
There's no business on that. You notice making it returnable on 30/9/2024. Miss D. Hazarika appears on behalf of the respondent number 1. Mr. H. Sharma appears for the respondent number 2 and 3. And you take for 4.
Yes, sir.
And Mr. S. Dutta appears for the learned standing counsel for the PNRD department appears for the respondent number 4. As the respondent numbers 1 to 4 are duly represented, extra copies of the petition be served upon them during the course of the day. The case of the petitioner herein is that the petitioner has approached this court challenging the notice dated 31/8/2024, whereby in exercise of the powers under Rule 18(2) of the settlement rules framed under the Assam Land and Revenue Regulation 1886, the petitioner has been asked to vacate the said land. Full stop. It is at the outset, it is relevant to take note of that there is no document of whatsoever being placed before this court. That the petitioner has approached the Circle Officer Lanka Revenue Service pursuant to the notice dated 31/8/2024. Be that as it may, the case of the petitioner herein is that the petitioner is running a shop, running his business, running a shop in a market shed which have been constructed by the number 2 Kaki Tai Super Gao Panchayat under certain scheme. However, there is no documents shown to the effect that the petitioner have been allotted such shop. The petitioner further the petitioner's further cases that he had been regularly paying the license fees in respect to the license fees to the Taki Tai Super Gaon Panchayat. In terms with Section 71 of the Assam Panchayat Raj Act 1994. It is therefore the case of the petitioner that the respondent authorities, more particularly the circle officer, Lanka Revenue Circle, could not have exercised the powers under Rule 18(2) of the settlement rules to evict the petitioner. During the course of the hearing, Mr. D. H. Sharma, the learned counsel appearing on behalf of the respondent number 2 and 3, have produced before this court two communications. The first communication is as regards a report given by the Latmandal, and the second communication is the report given by the Circle Officer Lanka Revenue Circle to the District Commissioner Huzai. The said communications are kept on record and marked with the letter X and Y. From a perusal of the said communications, it is seen that the land which have been, in respect to which the notice have been issued, that is land covered by DAG number 265 and 242, are lands which are specifically reserved Dark number 242 is reserved as a PWD road, whereas dark number 265 has been specifically reserved for public purpose, that is for Rak. What is that?
Rak Utsav Pathar.
Rak Utsav Pathar. Utsav. The learned counsel appearing on behalf of the respondent number 2 and 3 submits that it is on that basis the respondent authorities have exercised the power under the circle officer. Lanka Revenue Circle has exercised the power in terms with Rule 18.2 of the settlement rules, more so taking into account that these lands under no circumstances can be settled in view of the mandate of the settlement rules as well as the regulations of 1886. Full stop. This court have heard the learned counsels appearing on behalf of the parties and have given an anxious consideration as to whether any interim order can be passed. Full stop. It is the opinion of this court, taking into account the mandate of Rule 18.2, that if the land in question is a roadside land, has been previously reserved for roads or previously reserved for roadside lands, then such lands cannot be settled in view of Rule 26, 23. Cannot be settled in view of section Rule. Hang on. Rule 23 of the settlement rules. In addition to that, the land which have been specifically reserved for public purposes, for other public purposes, cannot also be settled. Under such circumstances, no person can have a bona fide right of claim over such lands. Be that as it may, taking into account that it is the case of the petitioner that the petitioner is running the shop upon being purportedly allotted to the petitioner by the respondent number 4, and it is under certain scheme. This court directs the circle officer, Lanka Revenue Circle, before carrying out any eviction to verify as to whether the verify along with the BDO of the block development officer of the, what is that?
Oh, my lord, I'm checking, my lord, under which blocking it is. Lordship may write concern block, my lord.
Shall make verification as to whether the land wherein the petitioner is running the shop falls specifically verified as to whether the land wherein the petitioner's shop is situated is a land which have been previously reserved for road or previously reserved roadside land, reserved for roadside purpose, and or for that matter have been specifically reserved for the specifically or specifically reserved for other public purposes, that is Rak Utsav Kotha. So if that be so, the if upon verification it is found that the lands fall within the said category as stated above, the circle officer, revenue circle shall proceed with the eviction in accordance with law. Full stop. This aspect of the matter be brought to the attention of this court on the next date by filing an affidavit.
Will be in the lumped in block, right?
No video, let's not bring the video. Because the video, what video has with business out there? If it is, whatever may be, it cannot be a construction only. If it is reserved for public purpose, it cannot be, no Gaon Panchayat can go. Because if I ask the video tomorrow, the video will, something will happen to that effect. First, video is not a party here.
Yes.
And because the video is not a party, tomorrow the video, if anything has been done, the video has done it illegally.
Lordship, the instructions provided, it is a 4 pages, Lordship, both sides, not 2 pages,
It's okay. I make it X and Y.
both sides.
Right.
This matter relates to non-payment of contractual bill, madam. And this
What
is
bill?
Non-contractual payment, non-contractual, contractual bill, madam.
Hmm.
And this is second round of litigation, my lord. In the
Hmm.
first round of litigation, my lord, the order is at page 50, my lord.
Yes, what is yours? Water resource, what is your standing?
BTC will pay the money, Lordship.
Huh?
BTC will pay the money.
BTC will pay the money. And the BTC is not a party.
They already made a party, my lord.
Then
Last occasion, they took time for.
no affidavit filed.
My lord.
How much you are entitled to?
My lord, 9,71,842.
Now, why this is the second round?
My lord, first round of it, the repetition, my lord, this order has been, my lord, disposed of as per Chancery judgment, my lord. My lord, order is at page 50, my lord.
How do you bring in Kamsarali? Yes? How do you bring in Kamsarali? Kamsarali, can Kamsarali judgment come into play after the AFRBM Act has come into play? Yes, finance. Yes, Mr. Borpudari. Now you can't do after the AFRBM Act has come into picture. You cannot do anything without the previous sanction of the finance. It is the requirement that wherever certain expenses are to be done, so there has to be previous sanction. And if it is so, how do you bring in correlate with Kamsarali? Kamsarali, if we apply after the AFRBM Act, wouldn't that be showing that certain amount which is being sanctioned for A project would be diverted to B? Because A for A, as per the AFRBM Act, has been already sanctioned. So how do you apply Kamsarali now after the AFRBM Act?
If someone has already executed the works and there is admission on the part of the state that yes, it has been executed, the person concerned and contractor has to be paid the bill. That is what.
Contractor has to be paid, but how do you apply Kamsarali? That it will be kept in a book and so it will be paid. Means Kamsarali is a circumstance where a particular amount is already lying out there. Whenever we get some funds from here, 1 to 10 will be first clear, 2 to 14 will be. But AFRBM Act says that against each project there will be a sanction by the finance. So under such circumstances, if that sanction is for this particular amount by the finance,
The concerned administrative department will have to move a special proposal before the government.
understood. But when you give a contract,
So post FRBM, my lord, it has to go within the parameters of my lord. that is
so
why-
FRBM Act came in 2015?
Five.
5. These are very recent ones. This happened when?
2009, my lord.
9.
9 words.
This is of 2009 contract. So if it is, how do you apply temporally then? Temporally would have been applicable earlier, but can you, in a sense, apply now? And more particularly, I had always the problem with temporally because it seemed to be a consensus. It is an order which is in consent that, okay, we are going to proceed in this manner. We are not going to insist on the question of limitation. We are going to implement, there will be a list prepared and this. And that too, it has been done by the PWD.
Yes.
How do you incorporate all these things in any other matter?
No, yes, that is of course there, but if we look at the from a different perspective, say for example, if a work is awarded, perhaps there may not be a sanction from the finance department, post finance department may be taken, post when there is a requirement of funds or for some emergency purposes, like lordship will very often find in construction of embankments and dikes. These matters seasonal character. So there administrative approval from the government as such are not taken at the initial stage because there is an urgency. It is done, then it is
No,
success.
that is understood. Then also post work also you have to take a sanction from the finance.
At one point of time, yes.
You have to take a finance. Now, if that sanction is given for one work A, how can you appropriate an amount in terms with temporally now?
It cannot be appropriated.
So therefore, how you see temporary basis is what? That there will be a list prepared on the basis of seniority. So on the basis of seniority, they will make the verification, keep it in the list. Whenever we get the money, we will keep on paying.
Just like in accountancy term, we say that it is FIFO, first in, first out, last in, first out.
Yes.
So here it will be last in, first out, first in, first out. So it is something, it considerably basically gives a leverage to the state government that look, there is a dearth of funds, maybe paucity of funds, but at the same time, since the contractor has executed their work, so let us not put them in strict parameters.
Because you have to consider,
Yes.
temporarily came at a point of time
But
when the state government's finances were in a very bad shape. They were at that point of doing is they were taking money from this particular client to the other one. This is how it has happened. Because temporarily happened at a later stage. Prior to that, there were many writ petitions which were being filed. All these matters were then referred as to whether, at the first question is whether writ can be exercised. That was the basis on which temporarily came, and it was a consensus. Now, how do you take care of it in view of the FRBM Act?
then
Now, can you still apply in view of the FRBM Act where in any manner the finance sanction is required? And it is then if finance sanction is required, then how are you, how do you apply temporarily now? Because it has to be sanctioned, then it has to be on the basis of the sanction.
the basis of sanction, yes.
Whether verification is done or not, that is immaterial. It has to be based on the sanction in view of the FRBM Act.
The basis of sanction.
So under such circumstances, you can't apply temporarily strictly.
Perhaps. Because if it is post September, this act, AFRBM Act came into force from September 2005. Now, if a contract is awarded post September 2005, and then the contractor is not paid, he comes up before his honorable court by filing a writ petition. And if that writ petition is disposed of in terms of temporarily, then that may give the government a leverage that to divert funds. But if
How can that be
yes,
there?
yes. But that if there some observation is made that in view of AFRBM, the fund has to be sanctioned from the department itself against that head of account, then perhaps it will cure to some extent. That is what I understand. Because
But would that not be overriding a statutory provision?
that is also one aspect of the matter.
No, this is a very vital aspect of the matter. Because if we keep on doing in this manner, it will have far-reaching consequences on the state at a later point of time. Because it would be difficult to adjust where it is to be paid.
Because temporarily it's a wide difference to the government.
Yes.
Funds are not available in this head, I pick up and I appropriate here.
In fact, temporarily, though the judgment is of the year 2008, should have considered the FRBM Act.
Perhaps my lord, it was not placed.
Hmm. But this is a very important aspect. That day I was just thinking, how is it possible? How do you take care of this situation? Means you will have a
For all my lord, fresh contracts, my lord, approval has to be taken.
no, because I think section 10 or something, no? And the BTC is nowhere to be found. BTC.
My lord, BTC.
BTC very difficult to find.
Respondent number.
We asked the secretary BTC to be present because in many cases we don't see him. Anyways, I'm filing.
Precisely in section 7,
Yes.
matters to ensure fiscal discipline.
You can't do that. So under such circumstances, it will have a very means you can't still apply considerably.
This, the very purpose of bringing this act was to ensure financial
Yeah.
discipline, like the economic health of the state. This is what my lord, the act proposes. Now, applying.
So
some-
therefore, with the FRBM, if there was no sanction taken for urgency purpose, then also merely because you are following the verification would not do. It will further require the sanction.
Then my lord, finance will have to take a call, my lord, in all such matters. File will have to be moved to the finance.
Chalo. Lakho. None appears on behalf, heard Mr. K. Sinha, the learned counsel appearing on behalf of the petitioner, Mr. What's your name? Siadas. Huh? Shi Sharma appears on behalf of the Water Resource Department. None appears on behalf of the BTC on call. Mr. Shi Sharma submits that the amount to be paid is by the BTC and not by the Water Resource Department, as it is a transfer subject. It is seen that on earlier occasions, the BTC authorities, as the standing counsel for the BTC, had sought for time. However, till date, no instructions have been placed. Under such circumstances, this court, considering the above, directs the additional chief engineer, Kokrajhar Zone Water Resource Department, BTC Kokrajhar, to be present before this court on October 1, 2024 at 10:30 a.m. The standing counsel of the BTC shall provide the video link shall appear before this court through video conferencing at 10:30 a.m. on 1st of October 2024. The standing counsel of the BTC is directed to provide the link. It is, however, made clear that if the state official is not represented, this court shall pass appropriate orders ensuring his appearance on another date on a physical mode. Yes, what is this?
Lordship, this matter regarding to non-payment of victim compensation, Lordship.
What?
The petitioner was murdered, Lordship.
Then
So accordingly, under 357A, Lordship is claiming the victim compensation.
murdered.
Yes, Lordship.
Who murders? Petitioner is murdered.
Petitioner's husband, Lordship.
Hey, Kaliyata, the husband, you know.
Your Lordship's one judgment is annexed here, Lordship. At page 79.
Lordship,
yes. One well.
the representation at page 74.
Last part, Lordship, I have. That being the position page 82.
No. Yesterday's order, day before yesterday's order is better. So there the order which I am passed is to the effect that thereby directing the district legal service authority to make those verification. And after verification, send the award to the commissioner and secretary, home and political, who said upon receipt of the award, disburse the amount within 2 months. First, there has to be an award as per file.
Lordship, in this case already awarded, the DLS is also not.
Award
Yes.
given, where is the award?
They have not paid the awarded amount. Lordship.
Where? Then what happened? Award passed.
Yes, Lordship.
So now the payment has not been made by the home and political.
Yes, sir.
Have you mentioned that? The award has been passed.
No, Lordship.
Then
After filing the representation that was rejected by the DLSA, thereafter again the petitioner filed an appeal.
Mr. If I have to pass the order, you have to produce this certified copy. Or file an additional affidavit, bring on record that aspect. Otherwise, for me to pass an order like this, it is not possible.
Okay, I will file an additional.
The learned counsel appearing on behalf of the petitioner submits that the respondent number 5 have already passed an award in terms with section 5, na? Clause 5 of the clause 5. Where is that? Victim's compensation is where?
Scheme, Lordship, at page 25, Lordship.
Where? Page
25. At page 25.
As per 5,
5.
clause 5 of the Assam Victim Compensation Scheme 2012, he submits that he may be permitted to bring on record the same by filing an additional affidavit. Good step. The learned counsel appearing on behalf of the respondent number who is appearing for 5? You are.
District Legal Services Authority, Lordship.
You are appearing, na?
Okay.
Appearing on behalf of the respondent numbers 2 to 2. 2 to 6 is directed to apprise this court as to whether any award has been passed, and if so, as to when the award has been forwarded to the commissioner and secretary to the government of Assam Home and Political Department on the next day. List the matter on 25/10/2024.
Unauthorized.
I'm appearing on behalf of Mr. Amy Mangalman. So,
You are appearing for?
Mr. Amy Mangal.
On behalf of Mr. M. Mondal, in this case, my lord, we want to file a rejoinder affidavit. My lordship kindly grant us some more.
You want to file a rejoinder
Rejoinder
affidavit?
file.
The learned counsel appearing on behalf of the petitioner submits that he requires 4 weeks' time to file a rejoinder affidavit, list the matter after 4 weeks.
Obliged, madam.
By last order, lordship has directed my lord the petitioner, that is the my lord collector and the government my lord, to file an affidavit bringing on record my lord the exact calculation of the land acquisition estimate. Now since my lord yesterday I have received the communication authorities are seeking some further time due to the fact my lord that this land acquisition.
Mr. Borbuzari, you are forgetting. You are always appearing on the this side. That is why you are forgetting. You are the petitioner. You are not making out a case. If you don't make out a case, I can't give you a time. I can dismiss your petition right away. No, nothing doing. Can't be like that. You are a responsible petitioner.
Yes, my lord, the petitioner
Nothing
are
doing.
seeking time. My lordship may kindly peruse this my lord.
And we are challenging what order?
My lord, the order my lord passed by the execution court.
Well, our writ is maintainable.
So far that
Regarding this lordship's last order is there. Lordship, this
No.
part has not entertained this part.
Has been filed by the petitioner along with the Iman. So and so in making payment of compensation in terms with the common Iman in various ways. And the petitioner have also challenged the various orders of these cases which have now been filed for non-compliance with the award dated so and so. At the outset, this court finds it pertinent to a well-settled opinion that suit of them cannot lie against it. The other issue involved in instance seems to be that the collector has applied various for and on behalf of the central government for setting up of the there. The dispute seems to be that the central government had not taken note of various requests made by the state for the release of the funds to make payment of them. On the other hand, it is the case of the central government that the state government as well as the collector have not provided the utilization certificate in respect to the payment of the amount of so and so. On perusal of the material, there is do not find that there is any narration of facts as to how the state has received any amount, money, and how the money has been sent. Accordingly, in the meantime, so and so are directed to file an affidavit stating as regards the preparation of the estimates for initiation of the land acquisition as to when the sanction was duly granted and as well. They'll also by indicating how much additional amount is required here.
They are supposed to file this.
You have failed to do so. The petitioner. So being a petitioner, you have failed. So you don't make out a case. We dismiss it. No, nothing.
lordship will kindly consider.
No,
My lord,
nothing.
so far as my lord, the proceedings, the execution proceedings, my lord, I am not praying for any interference. Although I have prayed in the my lord petition, but
I'm not, I said nothing. Are you, your execution proceedings going on now?
yes, it is going.
Not the pendency of this is they have filed a petition. So it is not.
I'll make it clear. Go ahead. Put the deputy collector behind bars.
And my lord, so far as my lord, since we have made out a prayer here, directing the my lord, Union of India and other authorities to pay the amount, being positioned.
You have failed to, for this court to exercise, you are to come up. You are not a respondent.
No, no.
You are the petitioner. So
Absolutely.
don't take it like if you are a respondent. So under such circumstances, if you have failed to come up, I can't help you.
My lord,
I gave you a chance on the last day, 7-8, but you have not failed to exercise
Therefore, my lord, therefore, at this stage, my lord,
cost.
my lord, my humble submission.
Cost?
Will be- No, my lord, since they are,
You are spoiling the time of the court.
lordship can give one last opportunity to the my lord petitioner, to the collector, my lord, to file an affidavit. Otherwise, my lord, lordship will take a call, my lord. Because admittedly, my lord, the practical difficulty is that, my lord. this
Because
land-
without these particulars, you have no case.
Absolutely correct, my lord. No, denying the fact.
So
but-
without these particulars, so as of now, why shouldn't this court take it as if, like if any other petitioner who comes before this court, if a case is not make out for issuance of any notice also, I dismiss it. Why the same parameters should not be applied to the state? You are asking for time. You, as of now, you don't have a case.
my lord,
You have not been able to, I asked you what? made it very clear.
Yes, yes.
You go for as regards the preparation of the estimate for initiation of land, as to when sanction was duly granted, how much amount was released by the central government and the IITG, how much amount has been paid to the
Yes,
beneficiaries,
Yes, yes.
how the additional amount so paid by so and so as stated in demand of the affidavit has been utilized. Because their basic thing is, the central government is saying, "Then look here, why will we pay? They have considered the 12 crores as their own money. That is the money which has to be given to the beneficiaries. We are not sure that they have given it to the beneficiaries." This is the stand of the central government.
That is the stand of the central government, my
The
lord.
central government seems to be correct when you are not in a position to produce. I have given you more than a month.
Now, my lord, the authority, my petitioner, the collector says, the collector is also a petitioner out here, my lord. The collector says that, my lord, since it pertains to the year 91, and in the meantime, my lord, there's two
You
districts.
could rush and file the writ petition in 2023, and you don't have anything in 1991. What to do?
One last opportunity, Lordship. Otherwise, I cannot make any further prayer, my lord. One last opportunity of 4 weeks, my lord. Otherwise, Lordship will take a call. My lord. That is the ground they are spilling up, my lord, that due to bifurcation of the district, my
But
lord.
Mr. R. Borpujari, the learned counsel appearing on behalf of the petitioners. Miss
Lordship, maybe please
Respondent who?
explain.
Central government?
A Gayan had.
Central government who?
A Gayan had appeared on the last.
She's not there. So I saw her today. She appeared on the A. Gayan appears on behalf of the respondent number 6. I've heard also Mr. R.P. Kapoti, the learned senior counsel, appearing on behalf of the IITG.
Time for 1 to 3.
And in addition to that, Mr. S.D. Prakash appears on behalf of the respondent numbers 1, 2, and 3. And so and so. Give you all your names. And again, also. This court, by an order dated 7/8/2024, taking into account the submissions so made by both the parties, had granted an opportunity to the petitioners to file an additional affidavit, bringing on record certain additional informations on the basis of which a case can at all be made out by the petitioner. However, the petitioners have failed to take that opportunity and file the affidavit. Today, Mr. R. Bapujari is appearing on behalf of the petitioners, seeks for some additional time. For the ends of justice, this court grants time till to file the affidavit on or before 23rd of October 2024. List the matter again on 25th of October 2024. It is, however, made clear that the pendency, that the pendency of the instant writ petition shall not be a bar for the executing courts to proceed with the execution cases which have been challenged in the instant proceedings. And issue appropriate writs for the purpose of compliance to the awards passed by the reference court.
One more observation that will give it one stick, Chairman, that if by the next day, no affidavit is filed, Lordship would be pleased to decide this matter on merits, my lord.
I said one final for interest of justice.
Yes, my lord.
You see, I would have otherwise said for other things, but for petitioners, I don't say, because it is he who has to come.
Absolutely. I take it. I am obliged.
What is this?
22 lordship may pay some more time to get the instructions lordship.
Why? You have taken so much of time.
Not received the
What
instruction.
is the matter?
Perhaps this is a mistaken identification of a particular plot of land. Government had initiated construction of houses under Prime Minister Awas Yojana. For that, they have sanctioned a plot of land. So instead of constructing house in that particular plot of land, they have occupied my plot of land.
They are constructed in your plot.
In my plot, they initiated constructing in my plot. That's my case.
Has there been an interim order?
Yes,
Interim order
yes,
is there,
interim
lordship.
order.
That is why I am praying.
Right now, I'm surviving on interim order.
Okay. I didn't extend the interim order last time. Anyways. hello. Mr. H. Sharma, it is seen that on various occasions, the government have been granted opportunity, but they have not come up with the instructions. Today also, Mr. H. Sharma, appearing on behalf of the respondent number 3, 4, and 6, submits that he would require some more time. For the ends of justice, this court grants a final opportunity to the respondent number 3, 4, and 6 to obtain instructions to place the instructions before this court by filing an affidavit. List this matter on 28/10/2024. The affidavit be filed by 24/10/2024. The interim order passed on 15/2/2023 shall continue till the disposal of the incident with petition. It is further observed that in the circumstance, the respondent number 3, 4, and 6 does not file the affidavit, this court shall dispose of the incident with petition on the basis of the materials already available on record.
23.
Yes,
As per last order, action was received to produce the instruction.
yes, Mr. Vottakur.
We have not received any instruction, lordship, we will.
I would know the affidavit has been filed for the ends of justice. How many ends of justice? There will be this ends of justice square. Tell me.
Lordship, if I may.
That day I saw one judgment of the Bombay High Court, whereby if the government does not file, the cost is being imposed. There the cost is a bit good. It's around 50,000 they impose. We may being the High Court, means this court being small and the here being here, we can put it at around 25,000.
Lordship,
We dispose of the matter.
Yes.
Directing release of the total amount and so and so. This is the amount you are asking,
Lordship.
non-payment.
Lordship.
Hello?
75 is the symphony lordship.
Okay, we
Yes,
dispose.
75.
This is it. Heard, Mr. So and so appearing on behalf of the petitioner. Good stuff. Mr. I. Vottakur appears on behalf of the PHE department. It is noticed that on various occasions, opportunities have been granted to the PHE department to file the affidavit, but for reasons best known, they have not chosen not to file the affidavit. Good stuff. The petitioner herein is aggrieved by the non-payment of its contractual dues, by the non-payment of its balance contractual dues, balance, na?
Lordship.
Of an amount of rupees 31,78,000.
That should be 41 lakhs lordship.
Huh?
That should be 41 lakhs lordship. Because some typing mistake was there. Lordship.
What typing mistake? You have made it 31 lakhs.
Lordship.
Everywhere it is 31 lakhs.
31 lakhs. Correction was made, your lordship. It is in middle, your lordship will see 16 lakhs, 13,000. Instead of that, it was written as 6 lakhs. As per sanction, page 75, lordship will clear it.
How did you correct that?
Lordship, it is at the time of, after at a Municipal Honorable Court, the permission was granted. And
No, you can't. Everywhere it is otherwise 16.
page 75 may.
Kindly see, why should I go? Page 8. Everywhere it is 31 lakhs. How can I do it? unless you amend your petition. Then everywhere, why should I make it 41? This is not possible. Where is the sanction?
Page 75.
Is this the amount 41 lakhs 25,000? 25.
Lordship, initial three lawsuit 16 lakh 23,000, 16 lakhs 13,000, and 9 lakhs 42,000. In middle 16 lakhs, it was written as 6 lakhs 13,000. That is why calculation has made as a 31 lakh. It should have been.
Okay. Now, the case of the petitioner herein is that the petitioner have not received the petitioner has filed the instant writ petition being aggrieved on account of the non-payment of the balance consideration of the amount to the petitioner against the supply of low-cost sanitary materials under the Nirmal Bharat Abhijan in pursuant to the supply orders dated 14/11/2013 and 4/1/2014. It is seen from the sanction order. Where is the sanction? This is not the sanction. It's the sanction.
Approval to release a lot. Pending in respect of pending liabilities. Was issued by the chief engineer to the member secretary.
Now kindly come to page 76.
Here also representation, it was instead of 16 middle, it was written as 630.
No, you yourself have written this. Can't help it. I can't help it. Every letter you have written it as 6. How can I make it 16? This letter also, your communication also is there.
But this sanction against.
No, that can't be done. There is no sanction. Is there a sanction, Mr. Bottakur?
That can be verified, Lordship.
It is the case of the petitioner that the petitioner have been issued various work orders under the Nirmal Bharat Abhijan by the respondent PHE department in respect to the Dorong, in respect to various divisions, that is the Dorong, Tinsukia, North Lakhimpur, Nagaon, bracket, Nagaon, and Kamrup, bracket, division 1. The petitioner have already received a part of the said amount in respect to the supplies so made. That is an amount of rupees 130.14 lakhs and rupees 41.25 lakhs from the Kamrup Division 1 and Nagaon Division of the PHE department. However, the petitioner is yet to receive an amount of rupees 9.42 lakhs, 16.13 lakhs and 16.23 lakhs from the North Lakhimpur Division, Tinsukia Division, and Dorong bracket Mongoldoy Division of the PHE department, being aggrieved by the inaction on the part of the respondent authorities for non-making payment in spite of the fact that the same have been duly certified by the Chief Engineer PHE Sanitation by the letter dated 29/1/2021. The petitioner has approached this court by filing the instant writ petition. Full stop. I've heard the learned counsels appearing on behalf of the parties and have given their anxious consideration to the respective submissions. Full stop. At the outset, it is relevant to take note of that the respondent authorities, in spite of various opportunities, have not filed an affidavit denying the claim of the petitioner. Full stop. Be that as it may, this court, taking into account that the amount the claim so made is out of the public exchequer, is of the opinion that in spite of the fact that the chief engineer PHE sanitation had mentioned in the communication dated 29/1/2021 about the fact that the amount of rupees 16.23 lakhs, 16.13 lakhs and 9.42 lakhs are pending liabilities towards the petitioner, this court is of the opinion that an opportunity should be given to the PHE department to make certain verifications and thereupon make payment. Accordingly, this court disposes of the instant writ petition, thereby directing the chief engineer PHE sanitation, who is the respondent number. I hope you have made him the proper respondent. Where?
Respondent number 4.
Where's the sanitation is where?
Okay, BNS.
Respondent number 4 to make the verification as to whether the petitioner is entitled to the said amounts of rupees 16.23 lakhs, 16.13 lakhs and rupees 9.42 lakhs on account of the pending liabilities towards on account of the procurement under the Nirmal Bharat Abhigyan in respect to the Dorong Mongoldoy division, Tinsukia division, and North Lakhimpur division respectively of the PHE department. After carrying on the said verification, the respondents shall release the payment of the petitioner at the earliest. The entire exercise be completed within a period of 4 months from the date a certified copy is served upon the respondent number 4.
In item number 18, Lordship.
Oh, he's not appeared, so we ask for personal appearance.
Lordship, I'm very much sorry, Lordship.
Huh?
I am very sorry, Lordship. I was on legs.
Can't help it. You have so many matters. Can't help it. The BTC should appoint some more people. When did they fix the matter? First of October, order to Miss R.B. Bora appears for a BTC and submits that a final opportunity may be granted to obtain the instructions as to when the petitioner, as to the amount to which, as to obtain the instructions. This court have taken note of that on earlier occasions also, the BTC authority have taken various adjournments, accommodations on the said aspect of obtaining instructions. For the ends of justice, a final opportunity is granted to bring on record by filing an affidavit. There stand. The affidavit be filed without fail by 30th of September 2024. On the matter be again listed on 1st of October 2024. It is made clear that if the affidavit is not filed, this court would be constrained to call for a personal appearance of the concerned officials.
I have informed the petitioner's advocate that I will request an arbitration. I have informed the petitioner's advocate that I will request.
Nothing doing. Next time you get your.
Definitely.
Yes, Mr.
Deeply obliged.
My please, also. Let's do my lord, on pay of the my lord policy amount, my lord. By the LIC, my lord. Here
You have
is
filed the affidavit. You are filing a reply?
my lord, no, my lord, the
Affidavit has been filed by who? Response
Uh,
number 1, 2, 3, 4, 5, 6.
LIC.
Then what do
Private
you want?
respondent, my lord, they have not filed anything, and it took time earlier also.
Why is private respondent required?
Because my lord, some portion of the, my lord, the policy amount has been provided to the mother, my lord.
Hmm?
Because there is a three policy before marriage, my lord, the policy has been opened, my lord. After the, my lord, death, my lord, I come to know here is a three policy, then I file the petition before the LIC, my lord, claiming the amount, my lord. So mother and brother was a nominee, my lord. So they have some amount they have paid to the mother, and some amount is keeping whole, my lord.
Who is paying for the private respondent?
I am paying for response 7 and 8. 7
You are paying for respondent number 7.
and 8.
8 is there.
Later on, my lord,
Later on,
my lord, the
Now
mother.
you are not filing an affidavit. Huh? Who could not come? Why do you need the mother? Under respond number 7 file it? Then
Brother
don't
is
come
there.
up with all these excuses. When you are filing it? Next week. If you have to file it next week, otherwise forget it. Don't come up with all these things. Mr. So-and-so appearing on behalf of the respondent number 7 and 8 seeks a final opportunity to file the affidavit on behalf of the respondent number 7 and 8. Full stop. List this matter again on 23rd of October 2024. Full stop. It is made clear if the respondent number 7 and 8 do not file the affidavit, this court shall proceed with the disposal of the writ petition on or before on the basis of the materials already available on record. The affidavit be filed by 21st of October 2024.
I love.
Interim order is there, na?
Well, interview.
Interim order passed earlier shall continue till the disposal of the writ petition.
Well.
Yes, BTC, we got your instruction.
Yes, Lordship, one page, I played two pages, Lordship. One here.
What is your instruction?
My instruction says, survey was conducted in the year 2017, when the land was yet to be settled in the name of the petitioner. And the land in that assessment, the petitioner's land has been shown as government land. And that is why zero compensation was assessed. And according to that compensation, the petitioner number was assessed for an amount of 4,25,000, and the petitioner number 2 for an amount of 1,55,000.
My lord, I am concerned about, my lord, their threatening that my patta will be cancelled. That is then.
It is a different case.
Land has already been acquisition.
Huh?
Acquisition as a government land.
No,
His case is that
my
for cancelling the allotment of land measuring 2 gotha, restraining the respondents from cancelling the allotment. You have already allotted him, isn't it?
yes, my lord.
Then
No,
why you are saying about Zirat and all these things?
because that land has been taken as government land.
No,
When?
how it can be?
In the year 2017 itself, assessment was made in the year 2000 survey.
When was the settlement given?
2020 laws.
Huh?
2020.
Page
Regarding delivery of possession, it has been informed that whereas The land
Page
described
14.
below has been acquisitioned under so and so. For the construction of Iman, the said land would be given possession on so and so at about Iman and so and so. Stated the compensation amount is calculated as concerned. Then submission of report regarding approval for land settlement at Iman.
Page 14 is the settlement, Lordship.
Page 18 is my lord the copy of Jama Bandi.
Huh?
Page 18 is the copy of Jama Bandi, my lord, my name is there.
Page 18.
My lord.
2020.
21.
Minal Kanti Das and so. As per the letter dated land measuring Iman, which was allotted to Dharani Kanta Das as refugee, has been allotted in the name of Minal Kanti Das and Midul Kanti as inheritance. So land has already been allotted.
My lord.
Where is your allotment letter?
My lord, page 15, page 14 and page 15. Page 14, start from page 14, my lord, my page 15,
Settlement
my
of land
serial
with
number
reference
15.
to the Iman, I am to directed to inform the borough land has received so and so on the following allottees given below, being the land value as premium from settlement of so and so. You are who?
I'm my lord, Mrinal Kanti Das and Mridul Kanti Das. Page, serial number 15, my lord.
Serial number?
15, 1 5.
This is 2 Katha 10 lectures of land. Dark number 8.
Tag number 8 and 6, my lord.
Dark number 8. So this has been given.
My lord.
So land has been already at the settlement and has been given.
Lordship, kindly see the second page, Lordship.
What is this second page?
One table is there, Lordship. Lordship, kindly see serial number 53 and 54.
This was done when?
2017,
And this order was passed on when?
20. That is
This
the
earlier, my lord, March 20, and then my lord, I deposit the money and the amount, my name was recorded in 21/8/20.
So is this a part of the? This is done under the 3H. This is being done under section 3.
Lordship. No, this is, here it is shown as government land, Lordship.
Understood. You may show whatever may be, but
Lord.
this is an acquisition proceedings under the National Highways Act.
Yes.
Yeah.
So National Highways Act, where is the notifications?
Notification, Lordship, that I have to produce, Lordship.
So we have not
This is
produced.
the only copy
Yeah,
I have.
this
been
is
furnished.
nothing to do. These are gazetted notifications. Now, what are these documents you are producing? This is not what is asked for. And this is a land acquisition case of 1/2023.
23, he is another person, he is not the petitioner.
So he's in the.
Huh?
In the same area, my lord, just 2, 3.
He is not the petitioner.
He's-
No, you have to produce before this court. You can't give up this type of documents out there. No?
I apologize, Lordship, this is.
No,
the
this
only
is not
document I
done.
have been-
The BTC has not complied with the complete instructions. Who is the person concerned? If he is not giving it to you, we will ask him from himself. Let him present. Ask the person of the circle officer to be present in the court. Now,
Lordship, today morning, she informed me that, she has not yet received the copy that I, wrote to the principal secretary, Lordship. In the meantime, it has been forwarded to her, Lordship. So she will furnish me a complete instruction.
oh, here is a case that certain land has been taken away. You are saying that it has already been allotted. You are bringing a case that it has, this land has already been acquired under the National Highways Act. Under what provision? When? These are not there. You are coming up with this document.
Lordship, this is the.
Can
serial
this
copy.
document have any relevance?
No.
Then this court had given a final opportunity by an order dated 22/8/2024 to the BTC to obtain complete instructions in the matter. However, Mr. P. Nayak, appearing on behalf of the BTC, have not produced any instructions to that effect. Full stop. The same clearly amounts to full stop. Under such circumstances, this court directs the circle officer, Gosaigaon Revenue Circle, to be present before this court on 1/10/2024 at 10:30 AM through video conferencing link to be provided by Mr. P. Naik, the learned counsel appearing on behalf of the respondent of the BTC, and explain as regards as to whether the land of the petitioner have been acquired in any land acquisition proceedings. Full stop. In addition to that, the respondent number 2 and 4 are also directed to file their affidavit in the matter without fail. Full stop. The interim order passed earlier shall continue till the disposal of the petition.
Lordship, I kindly call for personal appearance of the principal secretary, not the circle officer, because instruction was sought from the principal secretary.
I'm asking the circle officer.
Circle officer is not aware about the case. So today morning, I talked to her personally.
You are appearing for the circle officer?
But the instruction was sought from the principal secretary. That is the reason.
You have asked from whoever that is your lookout. I'm concerned because here is a case of cancellation of his mutation. The cancellation of the mutation would be done by whom? The set allotment would be done by whom?
Deputy Commissioner, District Commissioner.
District Commissioner will be, but District Commissioner is outside the realm of it. As per the BTC, District Commissioner's role is being done by the Director of Land Records. So under such circumstances, the District Commissioner has no business to cancel a mutation now because he falls under the state government. That is your own, what you call, circular. You have a circular for that. That is another matter which I am taking up, where your Advocate General is appearing as to whether, because that was an issue out there by which it is, the question is out there, that can you insert the Director of Land Records out there as the Deputy Commissioner?
My only difficulty is that I never informed her. So that is my concern. I keep writing to the principal secretary, but not to the circle officer once. It would have been his responsibility to seek instruction from the circle officer. That is my
Sure.
concern.
We pass that order then to the Principal Secretary as per your wish. Lakho. This court, by an order dated 22/8/2024, had granted the PTC a final opportunity to obtain complete instructions in the matter and to be brought on record by way of an affidavit. Today, Mr. Pina have produced before this court two documents which have no relevance whatsoever with the dispute involved, inasmuch as the dispute pertains to settlement of the cancellation of settlement allotment so made in favor of the petitioners, whereas those two papers, the documents so produced are just the documents so produced prima facie appears to have no relevance. Mr. P. Naik submitted that those documents are in relation to certain land acquisition proceedings under the National Highway Act 1956. If that be in the opinion of this court, the same submission seems to be completely misconceived, taking into account that if any acquisition is made under the National Highways Act, there would be notifications under Section 3 capital A as well as Section 3 capital D of the National Highways Act 1956, which are gazetted notifications which ought to have been placed before this court. Since those documents, on the basis of those papers which are being placed, no conclusions can be arrived at it is further seen that in spite of opportunities being given, the BTC authorities have not filed the affidavit. Full stop. And full stop. In the backdrop of the above, it is seen from the records available that the land in question at measuring 2 Katha 10 lectures covered by dark number 627 or Pata number 40 have been allotted to the petitioner and their names have been duly recorded in the record of rights. Full stop. Under such circumstances, there cannot be a cancellation of the settlement so made in favor of the petitioners without following the due process of law. Full stop. Accordingly, this court disposes of the incident with petition, directing the respondent authorities not to cancel the settlement so made of the land measuring 2 Katha 10 lectures covered by dark number 8/627 of periodic Patta number 40 of Revenue Village Srirampur Moza Santal Colony Revenue Circle Gusaigaon in the district of Kokrajhar BTC without following the due process of law. Full stop. Full stop. Accordingly, the question of eviction of the petitioners also does not arise till the petitioners have due rights over the land. With the above, the instant petition stands disposed.
Of the exhaustion. 27. Yeah, please. My lord, by virtue of last order, my lord, Forest Department was given the last opportunity to file.
No, my lord, we have
Till today, they did not file a petition.
My lord,
So, and
it was the first order of this petition. First order of this petition. They are claiming a right under ST/SC, but the Chakmas, Hailakandi, my lord, they are not, they don't come under ST/SC, my lord. And our difficulty is that some other departments have filed affidavit, they have not given us copy, my lord.
Who has filed affidavit?
I found
the
a
respondent
record from
number
this file.
6 has filed affidavit and they have categorically admitted my filing of, respondent kindly see the affidavit filed by the respondent number 6, my lord. And they have stated in paragraph 6, my lord.
Where is this land?
My lord, highlighted.
So it is in Assam.
Yes, my lord.
Lordship, there is a notification.
You belong to the Sakma community?
Chakma, my lord.
My lord, Lordship, there is a notification, page 358, which they have also admitted, my lord. 258, my lord. It is for general information to all civil tribes and other traditional forest dwellers who are settling in the forest areas of Hailakandi district can apply for claims. And
350?
358, 358.
358 is different. It is not a
And except
notification.
44, my lord,
Huh?
public notice. And except 44.
No, 356 is the submission of memorandum.
My lord, 358, my lord.
Huh?
358 page.
358.
Yes.
What is your page? 358?
It tells, my lord, 358 is a public notice.
Public notice? Mine is not.
And except 44.
Public notice is 351 and except 44.
Yes.
Yes.
It's for
There's
info-
general for all scheduled tribes and other traditional forest dwellers who are settling in forest areas of Hailakandi can apply for claims of title under the Forest Act to enhance and submit. Moreover, it is to be mentioned that Bormons are notified scheduled tribes in Iman. However, the scheduled tribe H and other area may also apply for other traditional rights if they are settled in the forest for 3 generations 75 by submitting. Yes, then
Yes, my lord, the affidavit filed by the respondent number 6 in their paragraph number 7, they have also admitted, my lord.
no. First of all, what is your right?
My right is that my since the year 2018, my lord, I have been applying for this my land rights, my lord, in prescribed for.
Under what category?
My lord, lordship,
As forest dwellers,
as forest.
not SC, ST.
for scheduled tribe and staying.
Fantastic. If it is a scheduled tribe,
Can-
no. If it is scheduled tribe, then show me the constitution order that you are scheduled tribe.
Yes, my lord, I have annexure A1, page 47, my lord.
Page
47, annexure 1.
47.
In the prescribed format, my lord, claim form for rights of forest and under the provision of scheduled tribe, my lord.
No.
Page 47. And this is your annexure.
This
What
is
is
the
this?
form- This is the form, my lord, along with the form I have annexed.
Where is the Chakma community is a scheduled tribe within the meaning of the order of 1950 or not? Answer that question.
Well, in fact, I have handed over that constitutional order. 1950 Chakmas were not there, my lord. 1956 they were brought in only to the reserve autonomous council areas.
Say annexure
Huh?
48,
Only
my lord.
the
I have
autonomous
annexed
council
that, my
areas.
lord.
Where?
Annexure 48403, my
I'll
lord.
mark it, Lord. Originally, they were not there. 56 it was amended. Chakmas were brought in, but only to the autonomous areas.
Lordship, the next page, Lordship will find part 2, 404 page, my lord. Chakma, number 1.
Chakma under the item on in autonomous district for entries 1 to 10 substitute. So only in autonomous district,
Yes, my lord.
Chakma will come in.
Yes.
Then,
These are from Hailakandi. These are not autonomous areas.
oh, then matter over.
Also, may kindly see, my lord, at least, the affidavit they has filed, my lord, by the respondent number 6, my lord, at page 409, annexure B,
40.
9. So, Lordship may kindly come to previous page, my lord, 408. This is in pursuance to.
There is no 408 and 409.
This is the affidavit filed.
I have only till 398.
No, I am talking of affidavit filed by the respondent number 6. my
Okay,
lord.
409.
408
Who is respondent number 6?
is the
Welfare officer.
SD subdivisional welfare.
No. You cannot come under the ST. Nothing doing. This is Hailakandi, you don't come. Matter over. There is no second question about. If it is given only in the autonomous district, you are not. Autonomous district does not include Hailakandi.
My lord, but they have very.
Very well. Let them verify whatever they like. If you come under the forest dwellers outside, other forest dwellers, it may be a different, but not as an ST.
Sir, let them file affidavit then, madam. They say that they will file affidavit during the.
Yes, you will file affidavit or not?
But now we'll file because we have a copy of that, whatever the other respondent had filed, madam. So we'll take our stand in affidavit.
Mr. Gogoi, I'm telling you, don't file your affidavit, the pass an order.
Already a order
I'm
is
very
there, my lord.
particular on this now.
My lord.
If you don't file an affidavit, I will consider you don't have anything to say. Don't come up with all these things.
My lord.
Because on the last occasion, you have sought for filing an affidavit. No affidavit has been filed.
That difficulty I pointed out, my lord, because we came to show the line department file, but we are not furnished copies, my lord.
7/8/2024, it is seen from the records and all earlier occasion, forest department was granted, however, no affidavit has been filed. To file the affidavit by 3/9, the observed if no affidavit is filed within the said period, the insert shall be taken up for disposal on the basis of the materials available. So no affidavit, forget it. We take up for the disposal on this basis. Unnecessary. Okay. Tell me,
Lordship,
what other rights you have? Forget about them. Now,
Lordship may give one opportunity to seek instruction, madam,
whom?
from my client, madam. I am a legal aid counsel, madam.
So what?
My lord, kindly one accommodation as to.
You are asking for a combination now.
My lord.
They don't want to file an affidavit.
Let me seek one instruction, my lord, one opportunity.
If your ground is only on the basis that you are an ST, you are not an ST. Matter over.
My ground is also that I have been staying there for 3 generations,
No.
my lord.
My lord, let's kindly come to the cost title, my lord. The age of the petitioners. 3 generations been
My
in the
father,
forest
my
tax since
grandfather-
75 years.
They
These are all
staying there,
62,
my lord.
35, 43. And the
Their grandfathers from the days of
eldest
the
person I see is, my lord, only one person, it's 81 years. That apart, my lord, all are below 75. 3 generations, the forest act says it's at 75.
No, as per this act, scheduled tribe and other traditional forest dwellers, recognition of Forest Rights Act 2006. You only don't require to be scheduled tribes.
Yes,
You can be other forest dwellers within the meaning of that act.
yes.
So consider,
No, my
Wait.
other, there's another aspect. There has to be 3 generations is there.
understood, can this court find out?
No, yes, Manoj. And that part, I'll just.
Let
point
them
out-
prove it.
Yes. Well, I'll just point out one thing, Manoj. The issue is,
No, they are not filing affidavit. No affidavit business.
Manoj, they say they are already residents of some village. If you are the resident of a village, which is.
Understood, Mr. Gogoi. Do you want to convert this court to the range officer's court?
No, no. Manoj.
So
I got the
better,
message.
better off you
Manoj,
do one thing. We dispose it of.
Manoj,
Directing you go and verify within a particular period of time.
Manoj,
Verify.
Manoj.
And if you don't find, because they would not come
Already
within the ambit of
Yes,
ST.
yes.
They would, whether they come within the ambit of the forest dwellers, as per the definition in that act,
Madam.
it's for you to decide.
Madam.
Decide it.
Just for a moment, my lord.
Don't come
Annexure
more.
B, my lord, they are affidavit in opposition, they say, my lord. Annexure B to the affidavit in opposition filed by the respondent number 6. With reference to the survey, I'd like to forward the name of the document, name of the petitioners, 115 numbers of document.
No, we are not concerned with this
Before
subdivisional
kindly
welfare.
verify
Mr.
the
Bakshi, we are not concerned. Your only question is
verification
that you people have been you do not come under ST. You are,
I am ST, my lord.
oh,
But not from,
you are ST wherever I'm not concerned. You are not ST for the purpose of the instant case. For Hailakandi, you are not ST. You may be an ST for the purpose of autonomous. You may very well go to the forest areas out there in the autonomous regions like Karbi Anglong or BTC or any other place. There you go ask for under this, you do it, but not for the purpose of Hailakandi. Matter is very clear. The petitioner heard Mr. D.K. Bakshi, the learned counsel, appearing on behalf of the petitioner. Mr. D. Gogoi appears on behalf of the Forest Department of the Government of Assam. And Mr. B.J. Talukdar, the learned counsel, appears on behalf of the state administration. State is there for the district administration. District administration. For the respondent number 1 and 4. The petitioners herein who belong to the Chakma tribe are aggrieved by the inaction on the part of the respondent authorities in taking steps in disposing of their applications seeking allotment under the provisions of the scheduled tribe and others traditional forest dwellers recognition of Forest Rights Act 2006, and as such have sought for a direction that the range forest officer Gormura Forest Range District Hailakandi to initiate under sub-rule 1 of Rule 12 of the scheduled tribe and other traditional forest dwellers recognition of forest rights close rules 2008 proceedings so that the petitioners can be granted the forest rights in terms with the said Act of 2006. Agote Act of 2006 going. Full stop. And where is that act? That act? 2006 Act. It is there in the Forest Regulation Act. Somewhere is there. Somewhere. Full stop. Although, so I've heard. From a perusal of the materials on record, it is seen that the petitioners herein have filed applications before whom? before the deputy commissioner and collector of the, in the before the deputy commissioner and collector in the, of the district of Hailakandi, Assam, claiming rights under the said Act of 2006. Full stop. A perusal of the said applications prima facie appears that the petitioner claims their rights on the basis of that they are scheduled tribes
There is a order of the Honorable Court earlier, but inside second head.
Now, Mr. Gogoi, how this caste certificate is given? This caste certificate will go then.
Yes, in fact, my lord, what I can find from the materials, my lord, the act is for persons who are residing when the forest is declared, already residing. In this case, they say that no, we are ST, we are covered, give us forest lands.
No, no, that is another thing. But
Caste certificate
no,
will go
no, if you see the constitution order,
back, my lords.
it is only for autonomous district,
Yes.
Sakma is there. Then how can this certificate be given that he is a scheduled tribe for residing in Hailakandi?
My lords is correct. State has to answer this, my lords.
There will be a scheduled tribe only in terms with that order, and that order cannot be touched by anybody.
My lords.
What is this?
But earlier, my lord, an order was passed in this kind of situation.
No, those are Boro people, my lords.
Huh?
There's a Boro, there's Bida Distillery, my lord, there's a Boro tribe, my lords.
Forest type actually.
That's a Boro tribe.
That is, these people are different.
Nothing mixed in.
No, it's a Boro tribe. Islari is a Boro, my lord.
Have claimed their right on the basis of that from the perusal of the applications, it is seen that the petitioners herein claim rights under the Act of 2006 on the basis of they being scheduled tribes, bracket hills, under the Constitution, bracket scheduled caste order, under the Constitution Scheduled Tribe Order 1950, for short, the Order of 1950. Be that as it may, it is also the submission of the learned counsel appearing on behalf of the petitioner that the petitioners have been residing in the forest area for the last three generations. During the course of the hearing, Mr. D. Gogoi, appearing on behalf of the respondent, Forest Department, have drawn the attention of this court to the Constitution, to the scheduled tribe, where is the clue? To the Scheduled Caste and Scheduled Tribe Orders, bracket Amendment Act 1956, by which both the Constitution, bracket Scheduled Caste, bracket close, Order 1950, as well as the Constitution Scheduled Caste, bracket Part C, as well as the schedule to the Constitution Scheduled Tribe Order 1980-50 were amended The learned counsel appearing on behalf of the Forest Department further drew the attention of this court that by this amendment made in the year 1956, Chakma has been brought within the ambit of the order of 1950 only in respect to the autonomous districts of the state of Assam. He therefore submitted that the petitioners herein cannot be considered to be scheduled tribes in the district of Hailakandi, which does not fall within the autonomous districts of the state of Assam. This court have duly perused the amending act of 1956 as well as the Constitution Scheduled Tribe Order 1950 and conjointly read it with Article 342 of the Constitution of India. And in the opinion of this court, that as the Chakma tribe have been brought within the ambit of the order of 1950, only insofar as the autonomous districts of the state of Assam is concerned, they would be considered as scheduled tribe only in respect to the said districts, autonomous districts, and not to other districts of the state of Assam. And in the instant case, the Hailakandi district. Under such circumstances, the petitioner's claim has to be restricted as to whether they would come within the ambit of forest dweller as defined in
C, madam. 2 sub C.
No, that is forest dwelling scheduled tribal. Means members of the scheduled tribe who primarily reside in and who dependent on forest. This one, no?
Then it has to be O, madam.
Huh?
There's other definition also O. Other traditional forest dwellers.
This is 4. Yes. This is other thing. As to whether the petitioner would come within the ambit of other traditional forest dwellers which is defined in section 2O of the Act of 2006. It is the opinion of this court that this adjudication can only be done by a fact-finding inquiry, fact-finding authority. And it is the opinion of this court that the respondents, more particularly the respondent number 5.
4 and 5, my lord. Let it be joined.
And more particular, and it can be done by the respondent by fact-finding inquiry. Under such circumstances, this court therefore directs the respondent number 4 and 5.
Procedure is laid down in section 11.
Huh?
Procedure is laid down in section 11 of the forest act.
Oh, right.
Who will do it?
Ram Savas shall call for the claims if they face. There has to be a permitting order.
No, my lord, that will go one step further, my lord. Here the question, my lord, as they are
Therefore, directs the respondent number 4 and 5 to verify as to whether the petitioners would come within the meaning of other forest dwellers in terms with section 2O of the Act of 2006. Upon such verification being carried out, if it is found that the petitioners come within the ambit of the said of the other forest dwellers in terms with section 2O of the Act of 2006, the respondent authorities, more particularly the respondent number 4, shall initiate the further steps in terms with the Act of 2006. This court therefore directs the respondent, therefore disposes of the instant petition with a direction to the respondent number 4 and 5 to verify as to whether the petitioners herein would come within the ambit of other forest dwellers in terms with section 2O of the Act of 2006, and upon the respective petitioners approaching the on the respondent forest dwellers. Full stop. In doing so, the respondent numbers 4 and 5 shall conjointly carry out the exercise by giving due notice to the petitioners. Full stop. The same exercise be completed within a period of 6 months from the date of passing of the instant order. Full stop. This court further directs that in the circumstance the respondent herein, the respondent number 4 and 5 after due verification finds that the petitioners or some of the petitioners come within the ambit of section 2O of the Act of 2006, appropriate steps be taken in terms with the Act of 2006. With the above, the instant petitions. Yes.
It's a matter relating to the allotment of land in the procedural scheme in Municipal. All the petitioners are small cultivators. They've been doing cultivation for their livelihood for about 50-60 years in continuation, and paying the TB revenue as well. And when the procedural scheme was announced, they have made application, and their applications have been entertained.
So your applications have been rejected?
No, my lord. Applications are still there, my lord. It is in the final stage. What happened, my lord? The geo survey has been made, and also the concerned circle officer has also submitted a report stating that there is an agricultural land, and they are the agriculturists, and they are continuing the agricultural practices for their livelihood. And our applications are in the final stage. So in the meantime, suddenly the district authority, land advisory authority, without giving us notice, they have Annexure 6, they have issued the notification that the plot of land has been allotted to a particular nursing institute, and thereafter we have approached this honorable court,
You are residing there?
Yes, sir. Yes, in that locality.
In that locality, or are you residing there or not?
No, we are permanently residing there.
In that land?
Yes, sir.
And now they have, the district, they have done that?
Yes, my lord.
And then you have approached this court?
Approached this court, my lord. But subsequently, my lord.
Has there been an allotment?
No, my lord, the process was about to be completed, but by the time this acquisition notification that has come in, my lord, that is under challenge, my lord. However, whatever that might be, my lord, very recently, they have filed the affidavit in opposition, my lord, where also in paragraph 9, they have made that our case has been under consideration, and they are considering that. in addition to that, my lord, we have filed the RTI to the district authority, the cycle officer, my lord. Copies are available.
But you can be given only 3 bighas of land and 1.5 bighas, two
No, my lord,
kathas.
that has been amended recently, my lord, after this 2019 policy, my lord.
Ah.
And that has been raised to 7 bighas and half bighas to 1 bighas, my lord.
Huh?
Half bigger to 1 bigger. Then in there.
Now the area is from 3 above after the month and before the month and after the month before the bighas shall be substituted by 7.
Yes.
And amendment of so and so is by 3 after the word so and so is 7. And 3.5 after the word so and so.
So that half is made 1 bigger, my lord, and 3 bigger has been made to 7 bigger after the amendment.
So the land now will be allotted how much? 8 bighas.
No, my lord, we have respectively, some are having 3 bighas, some are having 2 bighas. Less than the approved allotment.
Now what do they say in the affidavit?
In the affidavit, my lord, that in paragraph 9, my lord, they have said that it is in the consideration of the government.
He is entitled to get allotment as well, then he will get the same, but not as desired by him and as the plot of the government land which he is occupied in cultivation is required for establishment. This is an agricultural land.
My lord, another point, the recent development that has taken place, my lord, we have filed the RTI application and the cycle officer has said that they have chosen for alternative place. In spite of instead of this place, my lord, they have chosen some alternative
No,
place.
this land is given to you for agricultural purpose.
Agriculture purpose.
So there will be no dwelling house.
No,
This is for agriculture.
yes, agriculture purpose, my lord.
So they can very well give you in some other area. No problem.
My lord, no, the
Agriculture.
new proposal they have made, my lord,
Very well.
alternative proposal they have made, my lord, considering that is an agricultural land. My lord, that is why the agriculture should not be disturbed. And that is why from the district authority, my lord, they have chosen some other barren land of the government. And the cycle officer, your lordship will see that in the RTI application, the reply by the cycle officer is already there, my lord.
Hmm.
It is in particular Assamese, my lord, but then we have translated it to the last 2 pages, my lord. The communication of the cycle officer on 4/7/2024.
That's okay. Now what is to be done here?
The my lord, once they have already chosen an alternative place and their proposal for that, and it is under consideration, my lord. It is only the RTI information we have derived of it. And that being so, my lord, we will pray humbly that the give the direction to the appropriate authority to allot the land in terms of the procedural policy, my lord, as because our applications are at the final stage. Geo survey has been done. And as it is number of times, if the cycle officer has said that it is an agricultural land, they are continuing the agricultural practices and that way.
But do you have a right to choose?
No, so Milan, the place we have been occupying, Milan, and cultivating for last
I would have understood you have a house. It's a different aspect to the matter. But here is the question, it's an agriculture where you carry out farming.
Yes.
So do you have a right to choose?
No, my lord, right to choose means because continuously we have been doing, and in other areas, my lord, we have residents nearby, my lord, nearby. That is why, my lord, in one of the case, my lord, the government has told the generous here to grant 1 bigha of land for a homestead, my lord. The policy is also saying about that, as because we are dwelling in that area, so our interest may kindly be protected, because the policy is indigenous people, protection of interest of the indigenous people,
So therefore, the policy is for protection, so it will be protected. You will be
Minor,
getting the
no,
settlement. But
as
why?
because we
How
are
can
saying
you?
it that, no,
How
the
can you pinpoint
No,
this
I'm not
particular
pinpointing.
land?
I know what I'm saying, as because we are there continuously for 50, 60 years in perpetuation. And also our residences are there nearby to the agricultural field. We have been doing agricultural produce that way. So my humble submission before your lordship to consider, as because the scheme is for protection of the right of the indigenous people, and as they have already chosen the alternative place for establishing the nursing home, your lordship may kindly considering it from the humanitarian point of view, not the indigenous people who are suffering.
But Mr. Bopatra, if you see the land policy of 2019, it does not give you a right of choice.
No, we are not saying for the right of choice.
Then
Our prayer
you
is
may
that-
be entitled to a particular plot of land. It means it is not even a right. It's a consideration.
No, my lord, that right has been declared by the policy itself, my lord.
It is not a right, it is a legitimate expectation on the basis of a
My
policy.
lordship consider it from the humanitarian point of view also the crisis.
Oh,
is-
humanitarian point of
No,
view,
no,
I just stepped
humanitarian
in
point will
outside the
come,
door
humanitarian point
when
will
I became
come.
a judge.
Humanitarian point
No,
will come.
human is.
No, then why the policy is declared to be protection of indigenous people, my lord?
That
No, as they have already chosen the alternative place where they are going to establish this institution, my lord, without affecting the interests of the indigenous people, my lord, your lordship should consider that.
Mr. Bopatra, I think the best option is like this. Let me fix this matter on some other date. And there is an interim order.
It is there.
Because of the interim order, I hope the government gets frustrated and does not do anything with this BSc project there and finds out some other. Because the matter, if it next time comes before me, so it will be at the end of it. I am not going to give you a direction today. So let it be postponed to some other day.
My lord.
And without fixing a date,
Fine.
extending the interim order.
Fine.
So let the government get frustrated.
Fine.
And in the meantime, you carry out your cultivation.
Fine. Fine.
And the government is not saying anything.
Fine.
They are not bothered.
Fine.
But I don't know, there is an interim order.
There is an interim order.
Yes, but our affidavit says that we have already handed over the land to our affidavit at
Ah.
paragraph, my lord, 6. Last portion of paragraph.
My lord, my humble submission is not, it is factually not correct.
Where?
That last part, accordingly, the present deponent by the order dated 29/23 has directed the circle officer, Telamara Revenue Circle, to hand over the above mentioned land to the Director of Medical Education.
Possession handed over.
That has been handed over.
No, my lord. I defer to the
It
London
is-
Council, my lord. If your lordship comes to the RTI reveal, my lord.
RTI, forget about the RTI, but the thing is here, where's the handing over possession is there, na? In pursuance
if-
to the
if they-
Iman dated so and so, 14 bigas, handing over principal. Now, have you
No,
made
that-
these people a party? The medical education,
Therefore,
Their party.
they are party.
Yes.
And oh, they are not bothered also. Anyways, they say that they've handed over, you say not.
But it
Let
is not.
this thing mean.
The our RTI application, my lord, where the cycle officer has responded very recently, my lord, that will reveal the actual position. If the land has.
So are we to understand that the district commissioner has made a false statement before this court? You file an affidavit bringing this, then we'll catch hold of both the secretary, the circle officer and better off. If the circle officer writes all this, where is the this is some 14 bighas of land.
14 billion.
And why are all these petitions?
No, no, it is within 14 figures, but they are occupying 2 figures.
Huh?
Everyone is occupying portion of that 14 billion.
2
So
figures.
all these are 14 bighas.
Within 14 figures.
All these are 14 bighas.
14.
None appears on behalf of the medical, appears on behalf of the the respondent number 5 on call. Full stop. It is also seen that no affidavit has been filed by the respondent number 5. Full stop. On the other hand, it is seen from the it is submitted by the learned senior counsel for the petitioner that the lands in question are still under the possession of the petitioner. On the other hand, of the petitioners in the batch of writ petitions. On the other hand, Mr. Vijay Talukdar, the learned counsel, appearing on behalf of the district administration, has placed before this court the affidavit filed by the district commissioner, Punitpur, wherein at paragraph number 6, it has been categorically mentioned that the land has been already handed over to the medical and research department of the government of Assam. And possession have been already taken on
15/9/2023.
15/9/2023. Full stop. Mr. R.C. Bopat, the learned counsel appearing, senior counsel appearing on behalf of the petitioner, however, submits that the statement may not be accurate, taking into account that his clients have been recently given certain information under the Right to Information Act. He therefore submits that he may be permitted to bring on record those information by filing an additional affidavit. Lists the matter again on 30/10/2024. Awesome.
The ordinance does not reflect, my lord, the name of SC Health, my lord. So that may kindly be, my lord, reflected in the process, my lord.
In this case, we are filing our affidavit by tomorrow.
But my lord, one development is taking place, my lord. About 20 policemen went to my house. And since the wife of the police number 1 was there, she doesn't here. She's deaf in a sense. And no one.
Continuous torture, harassment, and attempt to
yes.
encounter
My lord,
son of the petitioner and even
yes,
the
to call
old
me.
ailing wife of the petitioner at the instance of local unit by foiling
Yes.
Iman. Who is the petitioner?
Petitioners are there, 2 my father and son. And
You are an MLA?
Who?
The petitioner?
No, not MLA. He was the block chairman of the Assam Gana Parishad of Lumding.
Now, Congress.
No, he's in the AGP. The
Then
dispute
AGP is with the government. Why are they
no,
are?
their dispute started in last municipal election.
Huh?
The MLA being the BJP, he wanted to give all the seats to BJP. And I being the block chairman of the AGP, I wanted to give 3 or 4 seats from my side. And there the dispute. And that ignited into such a way, even my son was sought to be encountered. However, he jumped from the first floor and even fractured his leg and saved his life. And they
Now, what do you want?
simply protection that and they were yesterday DS to Hojai called
So lumping.
Take
for-
immediate action upon the complaints in the FIR filed by the petitioner.
But all my complaints have been, serious complaints have been, my lord, they have.
Shall not be issued to direct, they provide
They
adequate
have,
police protection.
They have submitted an FR. And only they, the
FIR has been given.
in my complaint, almost in all cases, except one. And in their cases, I've been charged. We have,
But have you filed objection against that of FR? No.
I cannot go to lumping. We are now using driving, my lord, two-wheeler sub-owner. The wheelers were destroyed by police at night. All the furniture were taken away. And we had been driving out of lumping, my lord. We are now living on driving to, my lord, rapid
Mr. BJ Talukdar, last opportunity.
Tomorrow.
Mr. BJ Talukdar, learned counsel appearing on behalf of the state of Assam submits that the affidavit would be filed on behalf of the state by tomorrow. Post of list this matter again on 23rd of September 2024. 23rd not possible, 26th of September 2024. We'll try to dispose it of on that day.
Yes.
Petitioner in the meantime would be at liberty to file the reply. Yes, what is this?
But
Okay.
here in this case, a civil suit has been pending, my lord. In the meantime, what happened, a demarcation petition has been filed before the circle officer. And circle officer issued notice for demarcating that land. Against that notice, my lord, we have come before your lordship that circle officer has no authority to demarcate the land when there is injunction from the civil court.
What is the injunction?
Injunction is given that that order I have annexed, my lord. Injunction of the jail. Your lordship will turn to page 37.
It directed that the office shall not alienate the suit land in favor of the third party or create any charge or AR. That's the injunction.
That's the injunction.
You dismiss your petition. You don't have a case.
When the matter
Got a
is
stay also?
sub judice- matter is sub judice before the civil court, my lord.
How does it matter?
Not, demarcation cannot be done by the circle officer.
Circle officer cannot go ahead with the demarcation.
Demarcation, how demarcation will be done? Because the matter is sub judice.
So demarcation is only for giving a demarcation certificate. They will go and look into it. Whether what is the right on the or the dark numbers is there.
Yes, the land was, agreement for sale was there.
So what?
Agreement of sale is there.
Possession remains, Mr. Sheikh, the possession will remain as it is.
No,
Possession will not be disturbed. They will just carry out the demarcation and do the needful.
but,
Matter over.
they're taking that, they're taking that demarcation, my lord.
You make the
Enter
state, you
Enter
see,
into
this is,
possession of the land.
no.
Enter
nothing
into
to-
the possession of the land.
No, the possession, whatever may be, they will only make a demarcation and issue a demarcation certificate as per that office memorandum. What is that office memorandum? Government? Office memorandum? Dated 21, 2020 or 16 or something? Give it to me. Your case for dismissal right away. Lekhok.
That with that observation petition may be disposed of, my lord, not dismissed. Yes, my lord, because your lordship. that
I am
demarcation-
going to say, Mr.
demarcation-
Sheikh, I am going to say that they let them go ahead. However, without disturbing the possession of any of the parties who are
In possession.
and accordingly disposed of. Okay? I heard Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner. And Mr. Where is the revenue here? Mr. Arvo Pujari appears for the response number 1. Mr. Oh, you are there? Okay, so and so appears for the response number 2, 3, and 4. And your name, give your name, appears for respond number 5 to 8.
My lord, I may be excused, my lord, with instruction of my learned friend, my lord, I am withdrawing the petition.
Huh?
I am withdrawing this.
Oh, fantastic. Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner submits that the petitioner would not like to press the instant writ petition. Accordingly, the instant writ petition stands closed on withdrawal. Interim orders, if any, so passed earlier, stands vacated. It does, sir. You filed your affidavit?
Your Lordship, we have not received our record, Your Lordship.
Huh?
Lordship, the last occasion, please produce the record, Lordship.
You have not received your records.
Can you-
What is this matter? Setting aside the impugn order dated demand passed by respondent directing the eviction drive to be illegal in here. Respond number 5. You got an interim order? But you file your affidavit, there's no interim order, otherwise you'll pass an interim order. You are in possession,
No, Lordship.
you've been thrown out. So dismiss,
No,
withdraw. What remains in your
Let
petition?
them file the affidavit, Lordship.
What is there? Why do you think give them so much of problems? You have been thrown out then. What is your plan? Setting aside the impugn order dated 8/5. Where's that order 8/5? The undersigned invites tender for interested bidders following so and so. That has not been done. Directing the eviction drive to be illegal. That has been, you have been evicted. By restoring the land in question to the petitioner and removing the seal from the house. What right you have now? Nothing. Any right? Okay. The learned counsel appearing on behalf of the petitioner and respondent seems to be not aware of the facts of the case. Accordingly, the matter stands adjourned to be listed again on 23rd of October 2024. It is made clear if the stand is not brought on record on the next date, this court shall consider passing appropriate orders. Give your name, Mr. Talukdar.
My lord. This case, my lord, they filed this case, my lord. I reply, my lord. This 2 weeks time I'm giving, my lord. The matter, my lord,
What
regarding-
matter? What is that matter about?
Matter, my lord, regarding my lord establishment under weekly in the agriculture area. But I think my lord, it is establishing the eco-sensitive. group, my
Ooh,
lord.
that.
That matter, my lord, and that
Your lordship's order
Ah,
directing the deputy commissioner to pass a fresh order. And that has been done. And after that, the consent to operate has been issued by the.
that the brick factory near some, what do you call, Povitra. Povitra? Yes, yes. Oh, now you have been allowed to operate.
We have given the permission to consent to operate.
Uh-huh.
And we started. The period was for, if your lordship sees that order, now, interim petition we have announced.
So there is a stay order.
There is a little problem with regard to the order at page 20.
Hmm.
Okay. This is below in I 7882 of 2014.
the I is dictated item 54.
What are you asking, in the IE? Or
I
you want a
below-
vacation or modification of the order?
Yes, if your lordships kindly turn to first below the consent order.
When did you file this?
At page 25.
Yesterday they have filed it. Yesterday I received it.
It was filed on 10th of September. Okay. We do one thing. Mr. Goswami, I'll take it up on 17th. Oh, not 17, 19.
Can it be, my lord?
Problematic if your lordship don't mind.
I know, I'll take it up on 19 so that I can dispose it of them. Because this will, I will bring this as stay vacating, because this should not have come like this. It should have come up as a stay vacating. It will come up. Let him file, because 7 days he is entitled to file an apply. So let us have it 7 days, and we'll have it on 19, 7 days here from today, 10th, 17th, and 2 days, 19th.
Can it be on, my lord? Profit, my lord, convenience, my lord. Can it be on, my lord? 23rd, if I learn it in open agree, my lord. 24th, my lord.
No.
No,
You
my
see,
lord. Your lordship can. Next Tuesday, my lord.
19th.
That because it has been fixed, so there may be a little problem there. If your lordship will any other convenient day to your lordship.
Okay. We can, let's have it on 27th and direct this matter to be listed in the stay vacating column. It has been submitted by Mr. P.K. Goswami, the learned senior counsel, appearing on behalf of the private respondent, that an application for stay vacation, a modification, alteration of the order dated 24/6/2024 has been filed. Full stop. The said interlocutory application is registered and numbered at 2782/2024. Mr. Arbor, appearing on behalf of the petitioner, submits that he has only received the copy on 10/9/2024. This was an ex parte order passed.
Not expert. No, not expert.
Not expert.
Okay, full stop. Accordingly, list this matter on 27/9/2024 in the column stay vacating application. It will come up on the top immediately after the motions. In the meantime, the petitioners would be at liberty to file a reply to the interlocutor.
Here file affidavit today. Can it be on 19th regarding cancellation of registration? Cancellation of registration. Yes.
We'll have it on 19.
The 2 matters that we have filed. Lordship, we are supposed to file a counter. We'll file before 19.
Termination of the non-physical. List this matter again on 19/9/2024. Along with WBC number, you have another petition, na?
Yes. Not the same council, not item 46. Let it come and I'm.
19/9/2024. Mr. B. Gogoi, the Finance and Taxation Department shall file the affidavit in opposition on or before 17th/9/2000.
They've already filed. I'll file a counter.
This is not a,
Today
you are going to file a reply.
I'll file a reply.
So it has been, let this matter be listed again on 19/9/2024. The state respondents have already filed the affidavit. However, the same is not on record. Mr. A2D, the learned counsel appearing on behalf of the respondents, submits, a petitioner submits that he would file a reply in the meantime.
37.
Please, Lordship. This is a matter relating to cancellation of GST registration.
Affidavit is available.
Lordship, affidavit is filed by the petitioner. It's already filed. Lordship. We will not file a reply because they have.
List this matter again on 19/9/2024, along with a Agor petition. Agor petition.
only that Finance Act, Lordship, I wanted to now bring on record, the clause 118 of the Finance Act, which,
You do whatever you feel like. There's a finance act, it's okay. We'll see on that day,
that date, Lordship, I will say.
along with Agor petition. Yeah, Agor yes.
Much appreciated.
Cancellation.
No, madam, no. Since the appeal was dismissed under finance section.
Huh?
Appeal was dismissed on the ground of delay. The petitioner contention is that, they are covered by the. Petitioner contention is that, they are covered by the suo motu extension of Supreme Court order, my lord.
What?
The benefit of suo motu extension of Supreme Court order was not given to the petitioner, my lord,
By?
by the appellate authority, my lord.
Where?
What's the operating? The order is at page 132, my lord. And operating part is at page 141, my lord.
Arising out of the order filed by so and so.
Operating part is
Revision
141.
application under E of AS shall lie to the central government and may be as well. Which order?
132 and operating part is at 141, my
Filed
lord.
by the so and so.
There are
When was
30.
the appeal filed?
The appeal was filed on, my lord,
The-
18/7/20
Since the expiry of
25,
period of
27/5/23, my lord.
beyond one. No, here it says at page 142.
My lord.
In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that the longer period shall apply. Since the expiry of the period in the instant case falls beyond so and so, the benefit of the effort is not applicable. Means, when did you file the appeal?
The appeal was filed on, my lord, 27/5/23, my lord.
Huh?
27/5/23, my lord.
27/5/23.
Order was passed on 2nd February 22, my lord.
2nd February 22.
22.
22. 2nd February 22.
Sorry, my lord, appeal was filed on 27/5/22.
Wait. 2nd February 22.
Order was passed
22.
22,
2/2/2022.
my lord.
And then you filed the appeal on
27/5/22.
5/23.
22.
Okay. Then
Now,
what
my
is
lord,
your case?
my case is that, my lord, till 28th of February, my lord, 22,
28/2/2022
22, my
time
lord.
is there.
my lord,
Then thereafter your case is 90 days.
90 days, my lord. That benefit has not been given to me, my lord.
So we interfere.
For page 141,
It will be taken up on merits. What is there? Going on the usual limitation. You see, unnecessary matter has been pending out here. The instant petition has been filed challenging the order dated.
31/7/23.
Where is that order? 31/7/2023. Passed by the
Respondent number.
Commissioner Appeals, CGST, Central Excise and Customs, in appeal number. Appeal number?
It is, my lord, there.
Not number there.
It is there, my lord.
Oh, no,
Just below the deal number.
in order in appeal number 407 GHY bracket A oblique COM oblique ST oblique DIB oblique 2023 dated 31/7/2023. The sole ground on which the instant petition has been filed is that the petitioner was not granted the benefit of the order dated
Page 27, 127, my lord.
of the order dated 20
10 January 22.
10/1/2022 passed by the Supreme Court in misapplication in sumoto petition C number 3/2020. Mr. R.S. Mishra, the learned counsel appearing on behalf of the petitioner, submits that the order which was passed, the order of assessment,
My lord, what in original?
the order of original was passed on 2/2/2022. Full stop. The learned counsel submitted that taking into account paragraph 5, Roman 3
my lord.
of the order dated 10/1/2022 passed in sumoto petition number 3/2020. The petitioner could have filed the said appeal on or before 35 na?
55.
35 2000 March, April, May 35 2022. 90 days.
My lord.
Are you sure?
So sorry, 29th,
31,
my lord.
huh?
29th May.
29/5/2022. Full stop. In the instant case, the petitioner had filed the appeal on 27/5/2022. Full stop. However, the respondent, the commissioner appeals in passing the impugned order dated 31/7/2023 have failed to take into consideration the above aspect of the matter, and as such, the impugned order is required to be interfered with. Full stop. Mr. S.C. Kyle, the learned counsel appearing on behalf of the CGST, and Mr. B. Gogoi appearing on behalf of the state GST submits that they would not contest on the merits, they would not contest on this aspect of the matter, taking into account the order dated 10/1/2022 passed in sumoto petition number 3/2020. Taking into account the above, this court, having given an anxious consideration to the above submissions, is of the opinion that the petitioner had time to file the appeal on or before 29/5/2022, as the appeal has been filed on 27/5/2022. The said appeal ought to have been taken into consideration as an appeal filed within the period of limitation in view of the order dated 10/1/2022 passed in sumoto petition number 3/2020. Accordingly, the impugned order dated 31/7/2023 passed in order in appeal number 407/ZHYA so D is by the Commissioner Appeal CGST Central Excise and Customs is set aside and quashed. The in that view of the matter, this court therefore directs the Commissioner Appeal CGST Central Excise and Customs to decide the appeal on the merits. Decide the appeal filed against the order in original number 34/ST/ABJ/ACD/2021-22 dated 2/2022 on merits. With the above observations and directions, the petition stands disposed. State not there. State beside you. Yes, what is this? Hey, Goel, what is he done here?
My lord, I am appearing on behalf of Mr. Amit Goel. My lord, my senior, due to some unforeseen circumstances, is unable to be present here. My lord, a short date may be granted, 17th September, my lord.
What is this matter about?
Challenging the order of appeal.
What order? Passed by the respondent and the appellate order behalf, modifying the order dated to the extent of imposing interest to the tune of ruins. Okay, we'll have it. You got.
My instruction, let it be after 2 weeks.
Okay.
My lord, 17th.
No, 17 not possible. Impossible. You already have an interim order. Isn't there an interim order? So let it be there. So list this matter. We'll have it after vacation. Because the too many matters. You see, this is full of already so many.
My lord, third week of.
Just for example, I'm having on 17th, as of now, 38 matters. Then 1832 matters. These are not within taking others. 2348 matters are already there. Then how do you do it? You want to come up on Gandhi Jayanti? Then, okay, list this man. Mr. B. Gogoi, appearing on behalf of the state respondent, submits that he requires some, he requires some more time to obtain the instructions. Full stop. List this matter again on 28/10/2024. Full stop. In the meantime, the respondent shall bring on record their stand by filing the affidavit. Full stop. Interim order passed earlier shall continue till then.
Much of it.
Please, Your Lordship.
Yes,
These
Mr.
cases, 40, 41, 42, the affidavit of the respondents are awaited.
Oh,
The issue herein is the relief of being able to file an appeal in these matters.
Huh?
We are prevented from filing an appeal even though we have paid the demanded amount.
Well, my instructions are. For instruction, I can have it after 19.
I asked you to obtain an instruction as to whether the appeal filed by the petitioner have been registered. That was the instruction I sought for. I didn't ask for so many things. You have filed an appeal.
I have not been permitted to file an appeal
Why?
because the updated details of payment on the website are not being reflected, therefore my appeal bounces back.
There,
The
you are to file e-appeal,
appeal
but the appeal is not being taken.
is not being taken into.
Why?
Because the payment that I've made already to the website, that is not being reflected in the feed, relevant feed.
On 20th, no.
It's a simple matter you should do it.
On 20th.
Is the matter again on 29/2024, on which date the learned counsel appearing on behalf of the respondent authorities shall apprise this court as to whether the payments so made by the petitioner have been duly uploaded, reflected, inasmuch as on account of non-reflection of the said payment, the petitioner is not in a position to file the appeal. If not, do it. তিনটা matter আছে নাকি একেলগে? তিনটাই হ'ব। নাম একেনে?
41, 42 same.
Yes, no, 41, 42 same.
Same order, এটা order দিন। Yes, Mr. You got your instructions? Instructions?
My lord, the notification is of 1933, my lord. So, my lord, we wrote to my lord, the director of land records to get a copy of the boundary of that file.
Okay.
Easier notification.
What is the petitioner asking after
Not to
1933?
evict, my lord, them.
Huh?
Not to evict them, my lord, of them. And their lordship protected in other cases, my lord, of this. In this case,
He's born, his age is 35.
my lord.
Okay, Mr. J. Sutia, the legal counsel appearing on behalf of the AAC submits that the notification in question is of the year 1933,
8 July 1933.
10th of July,
8 July
8th
1933.
of July 1933. And as such, it is the petition, the respondents are trying to locate the same. Full stop. He therefore submits that some time may be granted in that regard. Full stop. List this matter again on 6th of November 2024. In the meantime, the respondents shall bring on record their stand by filing the affidavit. Interim order is there?
Yes.
Interim order passed earlier shall continue till then.
46.
It will be taken about 19 or GST cancellation.
Huh?
It will be taken about 19 GST cancellation.
GST?
Cancellation.
Okay. Affidavit not filed?
Filed today, ma'am. They have filed today.
The Finance and Taxation Department of the Government of Assam has already filed the affidavit. However, the same is not on record. List the matter again on 19/9/2024.
47.
Lordship, as per the last order, the respondent number 5 was asked to demarcate my land covered by DAG number 415 and Patta number 81. And thereafter file a report in this honorable, before this honorable court, whether or not any
Hearing on
construction
behalf
is
of
going on.
government submits that on demand there would be a spot verification to be conducted on which, oh, that land.
Yes, Lordship.
Has anything done?
I'm not sure. I was called for a joint verification. I went there on 7/9. But as per my instruction, the respondent number 5 was not present. I have
Who is
photographed
respondent number 5?
the assistant revenue officer. The notice sent to me also doesn't say anything about the assistant revenue officer.
Has claimed before the year has constructed the building.
We'll enclose the photograph also, my lord, who were present at that time, my lord. Present or say, I bring it on record, my lord. All this notification and the person who were present and the lordship can look into the sketch map which we have, my lord. Where the petitioner claimed his land, my lord, that is regarding the Manja bypass.
Manja bypass.
Manja bypass.
That is the where the petitioner's land is.
The petitioner claimed his land on that, my lord, but the green portion, my lord, Joguna D. Sheriff, that is a square mark is there, my lord. That he claims, but his land is, my lord, the, my lord, violet marks, my lord. Violet color marks is there, my lord. That is his land. Not
Oh,
there,
there
my
on
lord.
top.
Top, my lord. So bring it on record, my lord. Notice has not yet been issued, my lord.
Notice has been issued. Notice.
Notice has been issued, lord.
Mr.
My lord.
Mr. Sudhir, one day also I issue a notice.
Lordship,
I make it clear.
My lord, my lord.
for a moment, if your lordship comes to page 87, that is a speaking order passed by them.
Regarding, my lord,
They say Jamuna
demarcation.
DCRF is also not under any land acquisition process, Lordship. I don't
I'm
know.
not on concern. Your land is on top, somewhere else.
And we have already issued, my lord, last page, my lord, to demarcate the land of the petitioner in his present within 10 days, my lord. 9/9/2024, we have issued notice, my lord, to the ARO, my lord, that you are hereby directed to demarcate land covered by DAG number so village so within 10 days in the presence of the landholder C so.
That inspection of Iman. Where is the petitioner's signature? You have not taken his signature.
Signature is not there.
Huh?
Signature is not there, my lord, the official signature is there.
Lordship, nothing was done on that, Lordship.
What you are very much present.
Yes, I was present. I have that photo also with me, Lordship.
Then
That photo, but only the photographs were taken, the lands were not demarcated, Lordship.
no, the 10 days you are going to
10 days, my lord,
demarcate.
demarcated. So after 19th,
And Lordship,
Mr.
kindly.
J. Chutia, the learned counsel appearing on behalf of the petitioner. Submits that the joint inspection was carried out on 7/9/2024 and have placed on record certain documents. On the basis of the said joint inspection, as per the reports so submitted before this court, it transpired that the land covered by DAG number 415, PP number 81 of village Mohendijuwa, NC, is not under the alignment of the road constructed for NH 29. Full stop. This aspect of the matter is kept on record and marked with the letter X. Full stop. This court further directs the state authority, the Karbi Anglong Autonomous Council, to also bring on record these aspects by way of filing an affidavit so that the petitioner is in a position to rebut to such allegations. The Mr. J. Shutia, the learned counsel, further submits that that pursuant to the joint inspection, the demarcation of the petition land would be done within 10 days from today. Full stop. Accordingly, list this matter again on 28/10/2024. 28.
Lordship, yes, Lordship, till then, no work should be
No,
done.
nothing doing. It
Then
is
Lordship,
very clear.
then
We'll
respondent
see.
first-
No, if it is proved out there anyway, we will get compensation.
Lordship, affidavit may be filed on behalf of the divisional forest officer because they say that it belongs to Jamuna DCRF.
We'll look
But
at
there
it.
is no
Divisional
forest
forest
land.
officer is here or not?
Lordship,
Yes, he's party here, my lord.
he's a party, respondent number 7.
Is this matter on 28/10/2024? So on that date, the affidavit be filed by the Karbi Anglong Autonomous Council as well as also by the divisional forest officer, by the forest department of the government of
Respondent
Assam,
7, Lordship.
He's also under us, my lord.
as well as also by the divisional forest officer. It will be the same.
So, Lordship, I have instructions specific because
That
there
he is in your favor.
There is no no, Lordship, there is no forest land near my land, Lordship. They have earlier tried to show it as forest land by.
No, they are still now saying that it is not there.
I have filed an RTI before the forest officers, Lordship. They have said that is not a forest land. That is why I'm insisting on a.
They are still saying that your land nearby is not forest land.
Yeah, that I know, but
They are only saying that now the area where the road is passing through is covered by forest on both sides. That is their stand.
Lordship, that is why that the forest.
Okay, that is done. File your affidavit.
Highly obliged.
Okay, done. Stay with me. Yes. What is this?
Well, Lordship, may kindly take up item number 56, Lord.
Huh?
On 9th of
50?
August, item number 56, 8426.
56 to date.
8426.
8426. What is this?
On 9/8/2024, it's a, they have paid for compensation for acquisition of land.
Hmm?
But on 9/8/24, Lordship has directed the district commissioner to district administrator to file an
Which
affidavit.
is the subject matter of the instance as well as the court further finds it very pertinent to observe that the petitioner hearing has not been able to show the document by the initiation of the month wherein the petitioners. Is this the land? It's all because of the circle officer's problem. Is this the case?
That is it.
Huh?
Yes, that is it.
Where the circle officer one fine morning goes out there and finds out that in this land there is a railway track going on, and is that the case?
That is it.
Then
We have filed the affidavit. The district administration affidavit has been filed.
what is that affidavit?
So kindly see, Lord, paragraph 4, page number 35.
Department is gone.
Lordship had mainly two queries. Lordship had raised two queries mainly in that order. Number one, whether the land in question, which
Was acquired prior to that.
was acquired in that particular LHS or not in 88. It is acquired in 1988. It is the land.
Inadvertently mentioned the said land to be Exona land and also mentioned that there was no proposal for it. As the land was acquired way back in 1988 in respect of LA case number so and the land in question is already in occupation of VIA. As such, the soil is non-existent soil. So that is what, well, it was apparent on the face of it. I therefore pointed out, I think Mr. H. Sharma was
Yes.
there on that day.
Yes.
Ah, yes. What right you have? You don't have any right. One fine morning, somewhere, you got hold of a circle officer, he gives up a report that this particular land, this has been long acquired.
Lordship, till 2009, we were paying the revenue, and in 2009, Jamabandi also issued in our.
How can it be possible?
Yes, we have the original copy.
But,
Lordship may change.
You were granted a settlement when?
Suppose they are.
Where is the settlement in your favor?
What settlement we don't know. Actually, as per our knowledge, it was acquired in the year 2007.
If this land has been, no, this one land was acquired in 1988.
And Lordship, kindly see, there.
That you know, the railway department has already categorically mentioned that they had deposited the amount of Jirat and so in 1992. and the railway officer for the village state court. In this regard, your deponent states that on Iman, a request was made to the additional Iman to return back the original file of so and so. So and so, that the land goods were transferred to the court of Iman and till date the transfer of the resident. Thereafter, so and so Iman.
Beneficiaries, there are 10, Lordship.
No. We'll take it up at tomorrow at 2. This one we finish it off. Unnecessary, this matters.
Tomorrow, sorry, Lordship, I will go to Nalbari, maybe day after tomorrow.
What? You are from?
I will go to Nalbari.
You go to Nalbari, very well.
Sorry,
From there you,
Lordship.
there's a very good connection.
Lordship,
You finish it off. Whether you are there or not immediately
Day
at
after
2
tomorrow.
o'clock. Not
Fine.
day after tomorrow.
Fine, day after.
Day after tomorrow, not possible.
Only, I'm asking for one more.
In time order is there.
No, Lordship.
No.
Yes. Okay. List this matter on 24/9/2024 at 2 p.m. At 3 p.m. In the meantime, the petitioner, if so advised, may be at liberty to file a reply. Orders. Yes, any orders? Importance?
In item 59 interim may be considered.
Huh?
In item 59, there is the interim order.
What is that 59?
Regarding the demolition of the wall by the.
What is that instruction? What is that? Service complete. Why these the matters have come up for orders? How many orders are there?
So,
It
the
takes much
affidavit,
time.
we have filed respondent number 4 refused to. accept
Oh,
the-
yes, madam, what has happened to your matter 48? Yes, anything?
Some proposal was submitted for minute part.
I don't know how they're computing this proposal. It's 8 lakhs they're trying to sanction when our lordship has asked only one. They're trying to sanction 8 lakhs.
Huh?
I will have to focus. Their proposal is of 8 lakhs.
I do not know how.
I didn't ask them,
Yeah,
only, I asked them only 1
1
lakh.
lakh and 10,000 per month and 3,700 for the caretaker.
Not that I'm averse to it.
Then why?
Well, this is your 20th, I will come up with.
Come up, this is a violation, I'll then take it up with
40,
these
40,
people.
48.
Who is this person concerned? Now we'll ask the Director of Medical Service
The director health service.
Act to be present.
Let it be on
If
20th,
he
I
is
will
not
come.
understood, let me make him understand. List this matter again on 29/2024, on which date Mr. P. Gogoi shall update as regards the financial sanction. Next,
Deeply obliged, lordship.
49. 49 and 50, what is this?
59, lordship, for service report, we have filed an. affidavit.
49 and 50. Yes, Mr. B. Borua, what is this? This is complied?
Not complied according to us.
Is it complied?
Well, the NCL's Autonomous Council, they said, well, we have released some fund. They said that they have already disbursed that amount. And after that, they have sent a requisition for further amount. Well, I have sought instructions that what happened to the further amount of rupees. That I am awaiting.
Hey, Lakshman, can come on, you have us.
But
Yes.
I'm awaiting the instructions as regard the requisition for the further. Already, my instruction is that already some amount has already been, whatever amount they have asked, that was given to them. And that amount has been released to the petitioners for land acquisition compensation. Now they said that some more amount is required. On last occasion, they have placed a letter before your lordship. A copy has been given to me also. Well, I have sought for instructions. Well, I have.
File an affidavit.
I'll place.
List the
And-
matter again on,
Lordship, let it be after 3 weeks.
Huh?
Some, after 3 weeks. After 3 weeks.
list this matter again on 11th of November, 2024.
Yes.
On which date, Gustav? An affidavit be filed by the respondent as giving an update as to whether the order so passed by this court have been duly complied with. The affidavit be filed on or before 7th of November, 2024. Yes, then 51. You want? Yes, what is this? Complied?
Step was taken.
Complied? SC, PHE. PHE is not there. Why SC, PHE is there? Gayatri Vatsalji, she is not being represented. Okay,
Ma'am is reflecting in the court.
okay, tomorrow we send her to bring her. List this matter tomorrow at 2 PM.
Right.
Tomorrow we get her. Then
Oblige, Your Lord.
57,
It's a impleading petition.
Huh?
Impleading petition 57.
implead whom? Whom do you want to implead?
I'm that's respondent number 4.
You are the petitioner?
Yes, Lord.
You have objection?
Lordship, what happened in this case, the case is directed against the GMC, and he is one of my brother, and he has. No, Lordship, I have filed my objection.
Therefore, Mr. A. Sharma,
No, Lordship, I am SN Tamuli.
Mr. S.N. Tamuli submits that he would like to file an objection.
I have already
to
filed
that.
some file.
You have filed objection? Hello? Yo, I'll do that. 57, 58 is same.
Lordship, 58 is by them. 58 I filed against the unauthorized contract. Already he is there, so both are taken together. So, and
That is better.
on 9th of, now they have come for regulation of the unauthorized contract.
It's okay.
And on the last occasion, there's a read appeal, and in the read appeal, there is a direction.
This interlocutory application is filed by the applicant seeking impleadment to the impleadment to impleadment. Which one?
In read petition number 560, 560.
No, which one? 330 or which one? 280.
560.
Huh?
560. Oh, sorry, Lordship, I am.
Impleadment where?
In
What is your name?
Dibuga.
That I know. What is your name?
Pradip Hazarika.
Okay. Your IA 280 2802?
1280. I.
Huh?
1280.
1280 is not there. 2802 is there.
No, Lordship. 1280 is the impleading petition. In WBC 560.
1280. That is in WPC 560.
Yes, 560.
Now, this is an application heard Mr. D. Bulwer, the learned counsel appearing on behalf of the applicant, and well as Mr. S.N. Tamuli, the learned counsel appearing on behalf of the opposite party, appearing on behalf of the petitioner, and Mr. Anybody from the government today, anybody GMC, Mr. P. Nayak, you've seen, na? Mr. P. Nayak appearing on behalf of the Guwahati Municipal Corporation. This is an application filed by the applicant seeking impleadment. Seeking impleadment as party as a respondent number 4 to the accompanying writ petition, that is WPC number 5560/2024. Full stop. It is seen from the records that the petition applicant herein had also filed a writ petition being WPC number 3993/2023, which have also been tagged along with the accompanying writ petition being WPC number 560/2024. So taking into account the subject matter involved in both the writ petitions, this court is of the opinion that ends of justice would be met if the applicant herein is included as the respondent number 4 to the accompanying writ petition being WPC number 560/2024. Accordingly, the applicant herein is included as the respondent number 4 to the accompanying writ petition. Full stop. The counsel appearing on behalf of the petitioner, Mr. S.N. Tamuli, is directed to file a fresh memo of parties before the registry of this court within 3 days from today. Full stop. On the basis of the fresh memo of parties, due necessary corrections be carried out by the registry of the by the registry of this court to the cause title of this of the writ petition, as well as also update the same in the CIS. Full stop. Econ I stands disposed. Econ of Divo, econ for WPC number 560 of Nevada. Mr. Divo, appearing on behalf of the newly impleaded respondent number 4, submits that he requires 2 weeks' time for filing the affidavit. Full stop. Taking into account the above, list this matter again on 4th of November 2024. In the meantime, the affidavit be filed by the respondent number 4 by 22nd of October 2024. The petitioner, if so advised, would be at liberty to file the reply.
There is a development in between. So we have, against the interlocutory order, we have approached the Honorable Division Bench of this Honorable Court. And this Division Bench has dismissed the our appeal, but has directed us to amend the plea. Means directed us, given us liberty to amend the this writ petition 560.
Have you filed an IA?
Lordship, no, because yesterday that order was.
What
Sorry, on 9th.
Huh?
On 9th of May. Day before yesterday that order.
No, I've only included them.
Yes.
He has to file a reply.
Yes.
So he will file a reply, and against that reply, you file your reply, and then we take it up on, we have fixed it on 4th. Then 59. Oh, 59, he's seeking time, no, 4 weeks.
Services, we have filed an affidavit regarding.
You want to file affidavit in reply?
We have filed completion of the affidavit.
Huh?
That's the affidavit we have filed.
You have filed. Service is complete.
Respondent 2 and 3 accept, Lordship 4 refused to accept the same that his.
But you have filed that affidavit to that
Affidavit.
effect that he has received. Okay. You are appearing for
3, Lordship.
2 and 3 has received.
I'm
This
for
is
Who is 4?
4 denied to, refused to accept. We have
Hello. The house in 5259. Who has not received?
respondent number 4, Lordship. He is saying that his name is Shambhu Chanda, not Shambhu Shaha, Lordship. On this ground, he refused to accept. Lordship.
Who is number 4?
Shambhu Shaha, Lordship. We have been made in party as a Shambhu Shaha. His name is reflected in the impugned order as a Shambhu
Who
Shaha.
Saha is who? We are concerned with Silchar Development Board Authority, na? He has refused to receive.
Yes,
Why?
Paragraph 3, we have saying, Lordship, in the affidavit. Lordship.
And how are you connected with the respondent number 4?
I'm for 3, Lordship.
Understood. How is respondent number 3?
Filed a complaint, Lordship.
I made
against
complaint,
me.
Lordship, against that wall, what he has constructed, in front of the school. The land was donated by me.
The respondent number 3, pursuant to the notice dated issued on 7/8/2024, the respondent number 3 is being represented by Miss So-and-so, the learned counsel. She submits that some time would be required for filing a reply. You don't want to file? Okay. List this matter again on 4th of November 2024. The respondents shall also, the registry shall also give an update as regards the status of the service upon the respondent number 4.
Interim may be continued.
Interim is there. The interim order passed earlier shall continue till the next date.
Lordship, can you sorted may be given, Lordship?
Ultimatum? Huh?
Sorted may be given, Lordship.
For what?
My senior is better.
50. Huh? 60. Zero করছি। Zero. Okay, zero, yes. Why did it come? Service? Neither ID card nor has been received back a year. With the service not being complete. List the matter after 4 weeks.
Please.
Yes, if you got your instruction.
Come on, I'm actually out of the brief. Somehow, along with the health files, they get this file also.
Okay.
Well, let it be in case the affidavit has been filed. Then Lordship on after 20th. After 20th. Any day convenient, if possible.
2/8. When?
After 20th, 20th, 20.
To your
Any
office.
day.
Okay, list this matter on 25/9/2024, on which state the learned counsel appearing on behalf of the respondent number 1, 2, and 3 shall obtain the instruction in terms with the order dated 28/8/2024.
And we have taken a dusty service affidavit, we have filed already. Okay.
बच्चा था वो खाने के लिए हम नहीं आया खाने के लिए उस टाइम पे क्या करें? तो वो खाने आया लेने के लिए आया जाता है क्या करें?